All rise. All persons having business before the honorable judges now presiding for the District of Columbia Court of Appeals. Join me and give your attention. God bless the United States and His honorable court. This honorable court now in session, please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. We have 3 cases on our calendar this morning. The first case is 22 CV number 5, New Penn Financial LLC doing business as Shell Point Mortgage Servicing versus LaShawn D. Daniels et al. Counsel, when you're ready, if you could come to the podium and introduce yourself for the record and let us know how much time you would like for rebuttal.
Good morning, Your Honor. Ben Perry on behalf of New Penn Financial LLC, DBA Shell Point Mortgage Servicing. I would like to reserve 4 minutes for rebuttal.
Go ahead.
Thank you, Your Honor. This case revolves primarily around the decision of Judge Rigsby in the trial court to dismiss Shell Point's claims as a matter of law without notice or an opportunity to respond, and whether that decision complies with this court's rules and processes. Separately, and putting aside the procedural aspect, this case also involves whether or not the trial court erred in dismissing those claims as a matter of law as they pertain to unconscionability of the condominium sale. Specifically, whether it was improper under both a motion to dismiss or a motion for summary judgment standard. And we would submit that it was improper under either. Lastly, the case also involves issues regarding the constitutionality of the DC Condominium Act, which I'll refer to as the COA statute, and whether it is unconstitutional on its face for failing to provide lien holders or to failing to mandate notice to lien holders, to prior lien holders prior to extinguishment of their lien interests. There are 4 parties in this case. Shell Point is the mortgage holder. LaShawn Daniels, who is proceeding pro se in the trial court and did not participate in this appeal, was the borrower. Brandywine was the condominium association or COA that foreclosed on the property. And Tyroshi was the entity that purchased the property at the sale. The District of Columbia Attorney General's office was not a party to this case, but it has appeared in the appeal for purposes of defending the constitutionality of the statute. By way of background, in the operative complaint, there were 3 claims.
Counsel, we're actually very familiar with the record and we've read the briefs. So in the interest of time, if you want to just jump into your arguments.
Okay, absolutely. I won't recap too much of the 2019 order. I will just say that following the court's order, the initial motion was a motion to dismiss, or on the alternative motion for summary judgment. The initial order resolved all except the unconscionability claim. After that, discovery proceeded. It was extended several times. And in March 2021, the court entered a sua sponte order. And we would submit that that order was decided under a motion for summary judgment standard. Specifically,
Well, the judge said that, right? It's in the order that he's using a summary judgment standard.
okay. Yes, Your Honor, I understand that the parties dispute whether it was under summary judgment standard, but I agree that it did say that in the footnote. It was a little bit unclear because it said count 2 the way it was phrased. But I agree that it said here the court applies the summary judgment standard. And under that, there are 3 that triggers Rule 56. And under Rule 56, there are 3 circumstances which require notice and opportunity to respond prior to entering summary judgment. And those would be where the court enters summary judgment in favor of a non-movement, which in this case was Tyroshi. It also converted Daniel's motion to dismiss to a motion for summary judgment. And arguably, Brandywine was a non-movement as well, because Brandywine did not have a pending motion at the time the omnibus order was entered. Secondly, the court granted.
What do you mean it didn't have a pending motion? I mean, it had moved for a 12B6 dismissal or in the alternative summary judgment, and the court had only granted that in part. So arguably it was still pending, no?
Well, it also denied it as to the remainder of that motion.
So the trial court is free to reconsider motions that are before it though, right?
Correct. Under Rule 54, it could revise a prior order at any time. And However, when it is a summary judgment order, Rule 54 and Rule 56 must be read in conjunction together. Namely, when any of the three circumstances under Rule 56 exist, notice and opportunity to respond are required before the court enters summary judgment.
Can I ask you how that works? So if somebody files a motion for summary judgment, one party in a multi-party case somewhere in the world to which Rule 54 applies, and there's a specific argument that is raised, and that's fully briefed and argued, and the trial court ends up denying that motion for summary judgment. And then a few weeks go by and the trial court sua sponte says, you know what, I've reconsidered and I'm ruling the opposite way.
Yeah.
Are you saying that that's a violation of Rule 56? Even though the exact argument that the trial court is changing its mind on was presented, and the party who, will be damaged by the reconsideration sua sponte will have had a full opportunity to address that argument. You're saying that the judge nonetheless has to say, by the way, although this has already been fully briefed and argued, and I've just rethought, I have to give you notice and we'll have another round of briefing. Is that how you think the interaction of Rule 54 and Rule 56 work?
In that situation, Your Honor, I think the trial court would well be within its rights to reconsider as part of prong one, even though technically they are a non-movement at that point. But in this case, these
Well, just make
issues,
sure I understand your answer. Are you saying that you think the judge could rely on Rule 54 and not give notice and an opportunity to be heard? Or do you think even in that setting, that Rule 56 would require that the judge give notice and an opportunity to be heard, like a new round of briefing on the topic?
well, to be fair, Your Honor, the parties in that situation would have had notice and opportunity to be
I
heard.
understand. So I'm just trying to make sure I understand your answer to my question, because I was a little blurry about what your answer was.
Yes, so in that situation, I believe the trial court would be well within its rights because the parties
To not have any further
Correct.
process.
Yes, Your Honor.
So that it seems that means that as this all relates to your case, the question then becomes, how different are the grounds that the trial court ruled upon sua sponte later from the grounds that were presented in the original motion and originally rejected by the trial court? So if they're pretty much the same, then it sounds like you agree, no need for further process. If they're different enough, then your position is need for further process. So could you just, what's your argument about why the ground the trial court relied upon when it reconsidered was so different from the ground that had been pressed and previously rejected as to require, in fairness, further process?
It's a great question, Your Honor. And I'd skipped a little bit of the procedural background that would have covered the motion. So in Brandywine's original motion, it did not make any arguments as to unconscionability. It argued that as to count two, that it provided proper notice because the COA statute did not mandate notice to anybody other than the property owner or the mayor. As to both declaratory judgment claims, it argued only that the statute of limitations barred those claims. And in Shell Point's opposition, it did raise unconscionability for the first time in passing, although it wasn't explicitly addressed, or count three was not even attacked outside of the statute of limitations argument. It did make a statement, I think, at one point that the complaint failed to state a claim, but there were no arguments made in the motion specifically to unconscionability. And so Shell Point's brief on that issue in opposition briefly touched on that. In Brandywine's reply, it again did not even address the unconscionability issue. It continued to hammer on the statute of limitations issue, and in fact, talked about the fact that Brandywine had no reason to believe that it made misrepresentations because the law was unclear until the subsequent case law clarified that. I will say that the trial court in its order did consider the unconscionability analysis, and it looked at that, but for two reasons, I don't believe that the court would have been well within its rights to go back and revise that. First, being that additional discovery had been conducted since then, and the law had evolved substantially, and the parties were not able to brief the effect of that new law or present any new evidence that had been conducted between 2019 and 2021. And in addition, the parties, because it was not raised in the initial motion, Shell Point did not have an opportunity to present full argument on that point. There was never anything directed solely to that issue. It was only argued in passing by Shell Point as a ground to say that it stated a claim.
But you moved for reconsideration, right? So wasn't this briefed at that juncture? Why isn't this harmless? If you had an opportunity to make, you just said, look, there's new law and we did discovery and there are new facts. And so you had an opportunity to put that before the trial judge in a motion for reconsideration, no?
Correct, Your Honor. I mean, there was an opportunity in the motion to amend to make any such arguments, but that focused on the procedural nature of the motion and the fact that discovery had been conducted. I mean, there was obviously an opportunity they
Is there
could.
any impediment from you saying, look, we have material evidence that creates a dispute of fact on some legal issue that's relevant now under the new law?
Well, Your Honor, it wasn't even clear that there wasn't going to be additional discovery. If you look at the transcript hearing, the court, Tyroshi at the time.
It wasn't clear that there wasn't going to be additional discovery at what juncture. We're talking, the court has granted summary judgment. You're saying without adequate process, right?
Correct.
And incorrectly under Rule 54 and not complying with Rule 56.
Yes,
And
Your
you go back to the trial court and you say, wait a second, you haven't given us adequate process. We want to be heard on this new case law, RFB, which we disagree with. And you're now saying we also there was new discovery between 2019 and 2021. Did you put forward that discovery to the court in your motion to alter or amend? And if not, why not?
Well, Shell Point had prior counsel in the trial court, but the motion did not include any new evidence. I believe that ruling, though, even in the absence of new evidence, was plainly just incorrect as a matter of law. First of all, it ignored that RFB properties only dealt with how purchase price is measured as one aspect of the unconscionability analysis. Even in that decision, the court reversed and remanded it for further proceedings consistent with that decision. It didn't look at whether the COA sale could be set aside solely because of misrepresentations made by Brandywine without regard to purchase price as set forth in RFB.
And when you say misrepresentations, are you alleging knowingly false misrepresentations, or is your point broader than that and also kind of almost like mistake of law or mistake of fact?
I can't speculate as to Brandywine's thought process. I have no reason to believe that they intentionally misrepresented anything. But what the cases say is that if a trustee goes beyond what is required by a statute in making representations regarding a sale, once it goes beyond that, it has a duty to ensure that those representations are accurate. And to the extent it is going beyond that and making inaccurate misrepresentations, that is a basis to set aside the sale.
What is it that Brandywine, or you're asserting that Brandywine made a misrepresentation?
Yes, Your Honor.
And what was the misrepresentation and when did it occur?
So the notice, if you look at the notice of sale, it says that the property will be sold subject to all prior liens, the further particulars of which.
All prior lien or all superior liens?
I believe it says all prior liens. Could be wrong.
Sorry to interrupt. Please go ahead.
Maybe it said all superior liens.
The notice of foreclosure says this?
The advertisement of the sale.
Or the deed of trust said that it was sold? The deed of trust, which was generated after the sale.
So the deed, which reflected what was announced at the sale, because the advertisement said the particulars of those liens would be announced at the sale. Brandywine does not dispute that it was representing that everybody understood that it was being sold subject to the deed of trust. Tyroshi has taken a different position as to that at some point in the litigation, but Brandywine has represented that it announced that at the sale. There's no reason to believe otherwise.
So there are two different points that have been referred to thus far. One is the advertisement for sale, which does use the word superior liens, which is, I guess, is somewhat ambiguous in light of the subsequent development of the law. There also, if I recall correctly, there were assertions about what was said orally at the time of the auction. And do you recall the exact wording? My recollection is that the assertion was roughly that it was announced there too that the sale would be subject to liens. I don't remember the exact wording of what was asserted to be the case there. I'm curious if you do.
Yes, Your Honor. On AA 224, there's a memorandum of purchase at public auction. And it says the purchase price was $5,000 subject to senior lien. Presumably the
That's, I think, a little bit different from what was, I thought there was also an assertion about what was said orally at the auction itself. That's now you're referring to yet a third document.
Well, so the advertisement said that the particulars of the liens that would be sold subject to would be announced at the sale. think the only reasonable inference from that is that it was actually announced the sale because it was included in the deed. Tyroshi never seemed to object to the fact that it was included in the deed.
My question again is a little more precise than that, which is what, if anything, does the record show about? I have the impression it was undisputed that something about liens was said orally at the time of the announcement of sale. And I was just trying to figure out if the record is clear about what exactly was said, whether it was prior liens, senior liens, or what, and I'm a little blurry on that still.
Are you referring to the notice of sale or just anything in the record?
Yeah, I'm referring to whatever there might be in the record about what was said, which I'm only recalling blurrily right now, obviously, about what was orally said at when the sale itself was conducted.
I know the advertisement that was published in the newspaper, and it's kind of hard to read.
Yeah, that says on the second page of it, subject to any other superior liens.
Okay.
That's the advertisement. And then, as you pointed out, the memorandum of purchase says subject to senior lien, which is slightly different terminology.
And the deeds, I believe, specifically identifies the deed of trust.
That's correct. That's correct, as I recall. But I thought there was an assertion about what was said orally too, and I'm just not quite sure what that exactly was.
I'm not aware of anything in the record explicitly stating that. Like I said, all I know is that Brandywine does not seem to dispute in its briefing that, at least in the trial court, it said something to the effect of the parties understood that the property was being sold subject to the deed of trust.
Okay, so if that is, if we take that as a given, then what exactly is the misrepresentation?
Well, the
Because
misrepresentation.
the sale is occurring, right? In July of 2014. And this court doesn't decide Chase Plaza until August. So
Understood.
at that juncture, right? Reasonable minds might disagree about what the law is, which is why we issued a published opinion explaining and clarifying what it was.
Understood, Your Honor. What I would say to that is the law itself did not change. The statute said what it said. The court opinion only clarified that. To the extent that that represented a change in what actually happened, to the extent that anything pre-Chase Plaza, it would not have been that case. I believe even in Chase Plaza.
I understand that. I mean, I'm not interested in sort of change versus clarification semantics. I'm not understanding how this constitutes a misrepresentation, which is what I hear you saying.
Well, it was represented that the sale was subject to the deed of trust when in fact it was not being sold subject to the deed of trust. I mean, even if it was not an intentional
I
misrepresentation.
understand that. How is that a misrepresentation if the law is unclear at point A and becomes clear at point B?
Like I said, Your Honor, I believe that just goes to whether or not it's intentional. It's still a misrepresentation because that's not actually the case, even if there was uncertainty surrounding that. What they could have done is they could have just sold the property and said, there is a senior deed of trust on the property and not make any representations as to whether it was being sold subject to the deed of trust, which is something that was later clarified. Obviously, it was not exactly clear, but the statute said what it said. And once the HOA took a position on that, it made an inaccurate statement of law. They might not have been able to know that time because of uncertainty surrounding the law, but that doesn't make it any less of a misrepresentation in my view.
I still don't understand why it's a misrepresentation to say subject to any superior liens, and then it becomes clear that the first deed of trust is just not a superior lien.
Well, that taken alone would not have been. If that was all that had been said, then that would not, in my view, have been enough. And that would have been the proper thing, in my view, to do, is to just say it's subject to all superior liens, but not say or announce to bidders that this property is being sold subject to the deed of trust when in fact it was extinguished by the sale. Because what that did is it resulted in a purchase price of only $5,000. If they had just not made any representations, if they had just left it up to bidders to assess the risks on their own, it's very likely that the sale price would have been somewhere in the middle to account for that uncertainty.
Does your argument depend on the use of the word misrepresentation, or are you making kind of a general contract argument? And so let me give what I hope will be a simpler hypothetical and tell me what you think of it. So let's say you and I enter into a contract and it says I'm selling you half of X, whatever it is I'm selling you. And we agree on a price and we execute that contract. And then, 2 weeks later, a court issues a decision which says you can't lawfully sell half of X. any transaction that purports to be selling half of X is actually selling all of X. I mean, we entered into our contract in good faith. We thought we were selling half of X, one of us was selling, one of us was buying half of X, and we negotiated a price that reflected that understanding of the transaction. Now, all of a sudden comes, something that we were unaware of, we didn't predict, which says we thought we were selling half of X, but as a matter of law, we actually sold all of X. Is that something, leave aside for a minute that you're not a party to, your client's not a party to this transaction, which complicates things, but assume that then the seller in that hypothetical, I forget who that was, that's between you and me, comes back and tries to negate the contract and say there's like a mistake here. We thought we were selling half of X and I got a price that reflected that value of it. And now the law comes back and tells us that I actually, unbeknownst to me, sold all of my X and I got paid for only half of it. Is that just like a general contract law concept that you think you can invalidate contracts if that is the form of what happens? Or do you think it's special in foreclosure cases? Because I know you rely on some kind of foreclosure specific cases, or are you relying on like a general contract doctrine?
So the way that courts have generally looked at this is in equity. So it's not a contractual rule. And I realized I used the word misrepresentations. A lot of courts use different terms. Some just say representations. Some say irregularities in the sale. There are a lot of terms that are used, but the unconscionability analysis is often very specific to foreclosure sales. And here's why: is because two parties are making an agreement that impacts a third party's interest. Usually that is just the borrower. Usually it's the borrower that's raising a challenge to the sale because it's their property being foreclosed and it doesn't affect anybody else except maybe junior lien holders. In this case, you have a foreclosure affecting two other parties, both the borrower, who, if that purchase price only fetches $5,000, could be on the hook for a potentially large deficiency judgment, and the lien holder whose interest is being extinguished by the sale. So courts,
And who, it seems to me there's at least another possible theory of injury, which would be if the price had been higher, understanding the actual economic value as later determined by law of what was being exchanged, the purchase price at the foreclosure sale might have been high enough that some of the proceeds of the foreclosure sale would have flowed over to help satisfy the lien that was first in time but junior to the condominium super priority lien.
absolutely. And I think that's what.
But if that's the case, then under the circumstances here where it seems like it's undisputed the sale was advertised as being subject to the first deed of trust, your argument is that the price was unfairly depressed. So, we wouldn't have gotten the benefit of this overflow. I'm not seeing how these arguments connect. And have you made the argument that Judge McLeese has just spelled out for you?
About it being a contract principle?
Correct.
No, we have not, Your Honor.
That's not in your brief.
I don't believe so, no.
Okay, thank you.
Let me just ask you to, I wasn't so much, I guess, focused on whether a remedy of that sort would sound in contract rather than in equity. But my question was, I guess, more general, which is, do you think is your argument limited to foreclosure, where you've had these arguments about surprise and other defects in foreclosure? Or do you think there are similar equitable principles generally that would allow a remedy in a hypothetical like I was describing?
Well, I think that while the equitability or the unconscionability analysis is that we argue specific to this here, it also applies generally to contracts. A lot of these cases that we are looking at involve parties to a contract and whether or not a misrepresentation was made to them as a basis for invalidating that agreement. Here, obviously, we're a third party to that contract and can't really attack it under general contract principles. There are no misrepresentations made to us as a party to the agreement, right? So we were lulled into complacency by these representations, but this is not a.
How are you lulled? I mean, just on the timing, right? The condo foreclosure sale is July 2014. Chase Plaza comes down August 2014. And then my understanding is Bank of America, which holds the first deed of trust, asks if it can try and redeem Ms. Daniels' unit and is told, no, this has been sold. And then it subsequently assigns its interest to New Penn Financial doing business as Shell Point. So how were you lulled?
Correct. When I say we, I mean the mortgage holder. So collectively, Bank of America and Shell Point. I only have the benefit of the record that was included in the trial court and the record that's available to us on appeal. But what that email said to me was that this was ongoing and that they were making representations to lien holders that the property was being sold subject to the first deed of trust.
Well, the notice that was sent to your predecessor in interest doesn't have, if I recall correctly, any specific indication about it. It's a notice, you have an interest in this property, it's going to foreclosure sale.
Correct.
So there's no lulling in that document. And I
Correct,
didn't
Your Honor.
realize there was any allegation on the record in this case that your predecessor in interest in fact was lulled in some way by any action that was taken at any point by any of the folks on the other side of the podium. Am I missing something? Because I didn't realize there was an assertion of actual lulling by your predecessor in interest, of your predecessor in interest.
No, Your Honor, and there's no evidence in the record of that. It's just pure speculation based on that email that there's the potential that they were making these representations regularly, as they seem to have made in other cases. I believe Lou also involved similar representations. RFB Properties is the same thing. So it's not far-fetched to think that they were regularly making these representations to lenders who were inquiring about this. And this is something that has been playing out in Nevada for quite some time. I believe their first super priority decision might have been right around the same time as Chase Plaza. I believe it was probably in 2014. But there was substantial litigation over that and the banks were aware of it. There was hundreds of cases involving that. And so to the extent that they were representing that they were selling it subject to the deed of trust, I believe they would have been lulling those lenders into inaction.
So counsel, if you want to wrap up and say a few final words, your time is expired.
Okay. Just lastly and briefly, obviously, we briefed the unconstitutionality of the statute. I realize I'm out of time, so I won't get into that, but I do believe that the statute was unconstitutional, which has since been amended in that it did not require or mandate notice to prior lien
And
holders.
did you make that argument to the trial court?
No, Your Honor.
Any reason you can think of why we would address it then? I mean, the general rule is we don't address arguments that weren't made in the trial court. I think you could say some of our precedents suggest that's like a super rule when it's a constitutional claim and maybe an extra duper super rule when it's a constitutional claim based on a statute that has since been revised. So that's not going to come up again. Why would we tackle that?
I understand, Your Honor. I understand forfeiture is an issue, but that is discretionary, especially even on these constitutional issues. And I believe it would be worth addressing to provide some clarity. The court did address that in a footnote. I believe it was Chase Plaza, where it kind of suggested that the statute may be unconstitutional. And this statute was in effect for over 20 years. So it's highly possible that this issue will end up before the court if it's not addressed at this juncture.
Thank you, counsel. We'll give you a few minutes in rebuttal, and now we will hear from who's up next. I'm sorry, I forgot to go through the order of
No problem,
argument.
Your Honor. Good morning. My name is Ian Thomas, and me and my colleague Tracy Buck represent Apelli Tyroshi Investments.
Thank you.
I will be taking 5 minutes of time to address the arguments that were raised in our brief, and with a particular emphasis on the procedural issues that are before the court.
And then after you, I'll do this now. Who's coming up next after that?
Mr.
Okay, and then,
And Marcel for the district.
excellent. Thank you very much.
And Mr. McGarvel will be focused a little bit more on the substantive aspects with the Office of Attorney General dealing with the constitutional issue that they intervened on.
Terrific. And then we'll obviously give New Penn time to respond to all of the arguments that have been made. You're welcome.
Your Honor, this appeal is about applying this court's binding precedent in the context of a super priority lien condo foreclosure, which is precisely what Judge Rigsby did below. When he took his prior ruling that was pre-RFB, put it in the context of this court's decision in RFB and revisited it under Rule 54. There was no error.
Don't you think that New Penn Financial should have had an opportunity to speak to RFB?
Well, Your Honor, they did. they filed a motion for reconsideration after the court issued its omnibus ruling.
So is your argument contingent on that? I mean, are you defending the trial court's ruling in the first instance without giving them an opportunity to speak to that new case law?
I am, Your Honor. The court is under Rule 54 permitted to revisit any order that's
Why
not.
does Rule 54 have anything to do with this situation? I thought Rule 54 was a finality rule
Well, Rule
for
50
purposes of appeal.
If you look to the commentary that exists on Rule 54 and to its federal counterpart in the Federal Rules of Civil Procedure, it's designed to address the very issue that occurred here. An issue in which a court makes a ruling, and during an intervening period of time, the law is changed, clarified, a fact is changed, clarified, and it allows the court flexibility to go back to make sure that, frankly, the court got it right.
That you're quoting the commentary to Rule 54. I thought Rule 54 was about partial rulings and what could be taken up on appeal, right? As an interlocutory appeal and saying, or things need to be final, the whole needs to be final. Until the whole is final, new rulings can be, or old rulings can be revisited, but it doesn't speak at all to this procedural point that we're concerned about, which is giving the opportunity to the parties to revisit old rulings and comment on new case law that's come down from an appellate court.
You are correct, Your Honor, that Rule 54 does not address the ability to.
Rule 56, though, seems to address this issue.
Rule 56 does, Your Honor, and it is our position. I understand Your Honor spoke earlier about her opinion that the ruling was one of summary judgment. Our position is that it was one of a motion to dismiss under 12b6, and we certainly don't abandon that position. But that being said, even if it was a Rule 56 ruling, if there was any error, it certainly was cured through the motion for reconsideration. The motion for reconsideration allowed ShellPoint to raise any issue that they wanted. They could have argued RFB in its application. They could have presented new facts or other substantive evidence that would have supported their position, and they did not. In fact, the motion for reconsideration is devoid of any exhibits, any cites to record evidence that was outside of both the pleadings and the motion briefing that had occurred previously. It was simply silent on what the additional evidence would have been. And so we're sit here.
So what's the point of Rule 56's procedural guardrails that say, don't do this sua sponte, don't rule on grounds that aren't raised before you? If your answer is just, well, you can always cover that in a motion for reconsideration. Is your view that failing to adhere to Rule 56 in that respect is always going to be harmless because the non-movement always has an opportunity to move for reconsideration and raise whatever arguments they want?
No, Your Honor, that's not my position. I think the circumstances here allow for the motion to reconsider to serve that purpose. So this isn't
aren't the standards different once you're in a motion for reconsideration? Don't you need to show some, clear error that the trial court made, that they misapprehended some law? It's not just a straightforward second bite at the apple.
Correct, Your Honor, or that you failed to consider certain facts.
Mm-hmm.
And that wasn't raised here. And that sort of, I think, goes to the heart of why the reconsideration is sufficient to cover any sort of defect if there was one under Rule 56. The facts did not change. There was no additional evidence. What had changed?
You mean since the initial motion to dismiss / summary judgment motion? Is that right?
That's correct, Your Honor. There hadn't been any sort of factual development that would have changed what was before the court. What there had been was a legal development. It was as a matter of law. Now, if there were certainly facts that had been discovered during the period of discovery, which, by the way, had closed at the time the court issued its order, if there had been facts that had discovered that would have changed the court's analysis or certainly called into question its analysis under RFB, ShellPoint was free to raise them in the motion for reconsideration, and they just simply did not. There is a lot of speculation, but there's certainly no documentary evidence, affidavits. There's not even an affidavit that would have been submitted under 56F saying, here's the additional evidence that we would need in order for the court to address the court's considerations under RFB. Lest we not forget that Rule 56 provides for a circumstance in which the non-moving party believes that there is sufficient evidence or there is potentially the existence of evidence that would call and raise a dispute of material fact. And it allows them to put forth an affidavit saying, we're missing X, Y, and Z. And as a result, the court should either deny the motion without prejudice or hold it in abeyance until we are entitled to do this additional discovery and find out if there is in fact a fact dispute. There was no such affidavit submitted here. Really, the only thing that changed was not the facts. It was this point of law that was clarified by this court during the 5-year pendency of this case. At that juncture, discovery had been extended 4 times. Written discovery had been exchanged. There was a record before the court. And certainly, if RFB's decision was not applicable because of some sort of factual circumstance, under Rule 56, it could have been raised and it was not. Your Honors, I see my time is up. Unless the bench has any additional questions, I would cede my time to my co-counsel.
Thank you, counsel.
Thank you, Your Honor.
Good morning, Your Honors. Again, my name is Tom McGavro. I'm here on behalf of Brandywine Condominium. One small point on the procedural aspect of this. Counsel for Appellant said that the unconscionability argument was made in passing on the original motions with the motion to dismiss or for summary judgment. Actually, it was a 5-page part of the opposition to the motion to dismiss. I direct the court's attention to Appendix 211 to 216, where Shellpoint made that argument before Judge Rigsby. And Judge Rigsby's original order did address the unconscionability aspect of it and found that there was a question of fact. And that's, Appendix 244 to 245. Your Honor, I'd like to turn to 2 points, if I may. One is the point that Your Honor brought up about misrepresentation and lulling. And simply to state that, again, the sale occurred 2 months or 3 months before the opinion was issued in Chase Plaza. I would note that the Chase Plaza actually reversed. It was a summary judgment for the lender. And this court reversed, which means the trial court erred in that case in the law. And then it was another 3 years before Liu and 4700 Connecticut were decided. At which point, at that entire time, nobody knew whether the sale could be, whether a super priority lien could be foreclosed subject to the first mortgage. And in fact, Liu, again, it was summary judgment for the lender. So up until this court issued the Liu opinion, the trial court thought it could be sold subject to the first mortgage. I don't understand how Brandywine's notice of foreclosure could be deemed improper by a third party who wasn't at the foreclosure, including the predecessor. Bank of America, as far as we know, wasn't there either. I don't see how they could complain that the notice of foreclosure was a misrepresentation just because it stated what everybody thought the law was at the time. And Your Honor is correct. Bank of America got the notice of foreclosure lien. There's absolutely nothing in the record to suggest it got the advertisement. Nothing in the record to suggest that it got the deed of trust. In fact, the only evidence in the record suggests it didn't, because a year after the property was sold, Bank of America was trying to figure out how to pay off the condo assessments, which means either it didn't get the assignment deed of trust, or it didn't bother to read it when it got it.
So I mean, I think part of their argument is, well, take the intent out of misrepresentation and forget about whether or not it was an honest misrepresentation or possibly, an honest and reasonable misrepresentation. I think their point is, well, it was wrong.
Sure.
And it was represented as being subject to a first deed of trust. People would have reasonably understood it as subject to a first deed of trust at the time because Chase Plaza had not come out, Liu had not come out. 4700 Connecticut and RFB had not come out. Now that all that's been made clear, it seems that the sale was, predicated on a giant misunderstanding that has led to I think in the words of RFB, a bonanza for one party, getting a $200,000 property for about $5,000 and a pretty huge detriment to the lender who has lost out on a considerable amount of money.
Right.
There's one argument that I think is probably foreclosed by RFB that it's unconscionable based on the sales price, but they also have an argument that forget about what the sales price is. That's just a huge mistake underpinning this whole thing, and that's a basis for rescinding the sale. A mutual mistake between the parties. What's your response to that argument?
Well, to put it somewhat flippantly, Your Honor, how do we know it was a mistake? There's absolutely no evidence in the record of what happened at the sale. And Your Honor, there is no.
Well, the deed itself says what was sold.
The deed itself says what was sold.
And it says, if I recall correctly, that it was sold subject to a specified deed of trust.
That's right.
So that's a pretty good indication of what happened at the sale.
Well,
what
that
people
is
believed happened at the sale.
That is an indication of what happened in the sale, but it's no indication of what the parties were thinking. It's no indication of whether anybody else was foreclosed from bidding or lulled into not bidding.
Let me ask you, do you have a position about whether there is any reason to believe that there was fraud by any of the parties to the sale?
No. I don't
So if
think
that's
there's
true, there's no indication that the parties believed anything other than what the deed reflects. So
Yes.
I'm not sure why. You seem like you're kind of playing both sides of the case here a little bit at this point.
Yeah.
So do you dispute that proposition that there's no reason to believe that the parties had an understanding that is different than what was reflected in the deed?
I do not have any reason to believe they thought differently. No, Your Honor. But
And so assume we take the case on that premise.
right.
Then what is wrong with the theory that, leave aside for a minute the complication that it is a successor in interest to a non-party to the deed who's raising the claim. And imagine it said Mr. Daniels had come in after this sale and after Lou came out
Right.
and said, I now have I have this default, I have this personal judgment against me for a large amount of money. I thought what was being sold at this property, I had an interest in what was being sold was something that was subject to a deed of trust worth like $5,000. If I'd known anything different, I would have done, something completely different.
Yes.
Or imagine, so imagine Mr. Daniels, let's say, was there, or if he's a party, it's a little blurry to me, I guess, or again, take the simpler hypothetical where it's just a two-party contract. And someone comes in and says, we both thought, because we didn't understand what the law would later become, that it was a contract to sell half of something.
Right.
And in fact, we now later learn that as a matter of law, whatever we thought, whatever we intended, notwithstanding our good faith and reasonable belief, we actually sold twice of it. And if the party who only got paid for half says, I thought I was only selling half, I now sold it all, that price is, leave aside whether it's unconscionable because of the legal uncertainty about it, but that's just a defect, it's an understanding that entitles me to rescission. Is that a valid kind of contract claim, or is it not? You think?
I think, and this is where I was trying to go, at least, I think Your Honor has added a number of facts that simply don't appear here. The fact that, what we have in this record is that the association foreclosed and Taroshi bought, believing that it was subject to the first mortgage. And as an aside, under RFB, that sale price is not unconscionable. However,
the price itself is not unconscionable.
The price itself,
assuming that was a reasonable price given that set of
Right.
uncertainties.
Now, if Ms. Daniels, I think it's Ms. Daniels, I think she said somewhere in her motion that she had just given birth. So I was confused on that myself. But if Ms. Daniels had come and said, look, I didn't bid or I didn't do anything because I thought the mortgage would be taken over, you've got evidence of lulling, you've got evidence of mistake. Would it be enough to void the contract? That's a good question.
Just
I'm
back
not
to my
prepared to-
hypothetical for
yeah.
a second. I just want to say, do you think it's true that if two parties to a contract enter into an agreement, understanding the law to mean that the contract will transfer half of what the person, one of the parties to the contract owns, and the price is set accordingly. And the contract expressly reflects that understanding. And then later, a judicial decision comes out that says, actually, whatever you thought, as a matter of law, all of it was transferred. Is that a basis for rescission by the party who sold the property under the incorrect belief, or is it not?
Well, I hate to start picking this. I'm not, depends maybe on what X is, but I think when you're dealing with sort of inchoate rights, as opposed to, I meant to sell you half of this pile of ore, but I can't. I have
Imagine it's
some
half of a piece of real property.
piece of real property.
If that helps,
Yes,
could make
depending
it
on the
concrete.
timing of when the judicial opinion came out, depending upon the specific facts of the sale, it could be a mutual mistake. I can see, for example, I'm going to sell you half of X because I plan to live on the other half of X, and you plan to let me live on the other half of X and manage your half of X. So I'm going to stay on my half. I'm going to manage your half and make sure it stays, it's kept up. All of a sudden, the court says you can't do that. You got to move. Well, I think there you've got a good claim for mutual mistake. On the other hand,
Do you
and if I
think mutual mistake was litigated in this case?
no, it wasn't, Your Honor. It was not. I was reminded years ago, this court came up with an opinion on the duty of care for commercial property when snow's falling. When does it have to clear the sidewalk? And this court said, and I paraphrase because it's been a while, but the court basically said the bench and the bar have been working under the assumption that the property owner doesn't have the duty to clear the sidewalk until after the snow has stopped falling. That is not the law. That has never been the law, and we now set the record straight. Again, I paraphrase. That's not exactly what the court said, but that was the import of the opening of that opinion. Judge McLeese, how many in the years before that opinion came out, how many settlements had been reached in slip and fall cases where one side or the other was thinking, I don't know when snow stopped falling, so I don't know what my liability is. I gotta, I may be in danger here.
Can I ask you back to your question about what, I mean, it's certainly true that the idea of rescission of a contract based on mutual mistake was not briefed in those terms. But what was raised, at least in the brief in this court, was the idea that the parties to this transaction didn't understand what was being sold and that the foreclosure sale should be set aside for that reason. That's, I'm talking about their surprise, their surprise argument and the like.
Right.
And that's in the context of a form of unconscionability is their claim. And why is it that shouldn't be, do you think that's not a valid form of unconscionability that could justify setting aside a foreclosure sale? Again, in the hypothetical where, let's say, again, there's a foreclosure sale and it's advertised as selling, half of lot X. And that's how it's advertised. Leave aside the lulling. That's how it's advertised. That's everybody's understanding to the party. That's what the deed reflects. And then there's a later judicial opinion that says, surprise, actually, you can't sell half of lot X. The law requires that any sale that purports to be a half of lot X is a sale of all of lot X. And if the party who, at the foreclosure sale had half of lot X sold, they thought, comes back in and says, now I've lost all of my property. And I didn't understand that. And this is just a completely invalid, fundamentally misconceived foreclosure sale. Would that be a valid reason to set aside a foreclosure sale at the request of somebody more directly injured than I know the hypothetical is here? I'm trying to take out that complexity for the moment.
Yes, Your Honor. And I think the point I'm trying to make, and maybe I haven't made myself clear, it depends. I think that is a very fact-specific question.
But you think that you agree that argument was made in the brief on appeal, at least, leave aside for a minute the trial court, I haven't gone back to look at that, but in the brief on appeal, one of their arguments is, leave aside price, this was a fundamentally defective foreclosure sale because the people didn't understand what was being sold. That, I thought, point is in their brief.
It was raised, but it's not supported.
by
by
facts
any,
of law.
by the record evidence.
And what's
by-
missing, I thought you were agreeing that there's no evidence that any party understood anything differently than what is reflected in the deed. And what is reflected in the deed is that all that was being sold was property subject to the bank's lien.
Yes.
And we now know that's not true because the combination of Chase Plaza and Lou together tell us that's not true.
Right. What's missing from the record evidence is the second part of Your Honor's hypothetical, which is, and the parties were caught by surprise and one of them wants to rescind.
Well, for sure, the last part is.
Yes,
Because
but-
then that's back to the complication of, the additional complexity that they're a little bit more of a stranger to the transaction.
Right, right, right.
I get that.
But what we're missing in this record is any sense of either surprise or,
That's where you lose me again, because you
Okay, I'm
acknowledge
sorry.
that there is no indication in the record that anybody had an understanding of the transaction other than what was reflected in the deed. So they had to have been surprised.
yes.
That's where I keep thinking you're circling back around to the opposite side of what you're normally saying.
All right,
Do you dispute that the parties to this transaction were surprised that instead of selling what the deed reflects as a matter of law, what was sold at the foreclosure sale was something that was not subject to the bank's deed of trust? You dispute that?
I dispute it's not what they expected when they had the sale, but.
The double negatives got me a little confused, so.
Yeah. I think the matter of surprise in Your Honor's hypothetical depends not on what happens later from an objective standpoint, but what the parties believed when they entered into the transaction and what they hoped the transaction would in fact result in. To my fine tuning or change of your hypothetical was that one party intended to buy half of X and have the seller live on the other half of X. They intended for something that the law said was illegal. So what they ended up with was not what either one really wanted. All we have here is the association foreclosed, and it did, and the law said that's okay. Taroshi bought, and it did, and the law says that's okay. But what's missing from their argument is any indication that Taroshi should have paid more. We don't know that he should have. It should have. That somebody else would have paid more if they knew it was not subject to the first mortgage. Or that Ms. Daniels somehow would have done something. Or for that matter, Bank of America would have done something if it knew it was not subject to the first mortgage. There is absolutely no indication that any party in this transaction would have changed their position had you come out 4 years earlier.
Are you saying essentially that any individual subjective understanding is actually irrelevant just because the law was unclear? And so this is about assessing risks and making investments. So whether anybody has some sort of prescient feeling of, I think this is where the Court of Appeals is going to go interpreting this statute, it's really neither here nor there, right? The law is unclear. Chase Plaza has not been decided
Right.
at the time that this transaction takes place.
Right. I'm also always hesitant to say that something is completely irrelevant. But I think in this case, that's exactly right. It's whether or not, well, I don't think Taroshi was particularly prescient. I don't think the association particularly was prescient. I don't think either one of them knew what this court was going to do 4 years later, or even 2 months later. They made a bargain. And under RFB, you look at what they knew at the time of the sale. And on June 24th, I believe it was, what they knew was there's a very good possibility or probability that this parcel is being sold subject to the first mortgage, and the sale went on accordingly. And if you had come out the other way, Taroshi would be on the hook for $210,000 or $209,000.
Council, we've kept you up here for quite some time. We're
You
gonna
did, and
hear
I apologize, Your
from the district now. Thank you.
May it please the court, Marcella Coburn for the intervener, District of Columbia. The court should not reach Shell Point's forfeited constitutional claims. Shell Point concedes that they never raised these claims in the trial court and that the ordinary rule is that review is limited to properly preserved claims. That is extra true in the case of constitutional claims. And there's also no reason to depart from that rule in this case. Shell Point never even offered a reason until its reply brief. Even then, in its reply brief, it didn't discuss its takings claim at all. It hasn't discussed that claim at argument. So I think that claim has now been abandoned in addition to being forfeited. But to address the due process claim, in its reply brief, Shell Point says the court should excuse the forfeiture there because Helen Dwight Reed, a case from this court, says the court can excuse forfeiture if there is a clear miscarriage of justice on the face of the record and if the case is presenting only legal issues, not factual issues. That is not the case with respect to their facial due process claim. There's a key issue that I think Shell Point has skirted around a little bit, but it came up at argument earlier, which is that its assigner, Bank of America, received notice of the foreclosure sale. That's in the record in the appendix at pages 189 to 192. And if Shell Point or if Bank of America did receive actual notice, that would be fatal to a procedural due process claim. And, even if the court has some doubt about whether that certified mail receipt to the Bank of America addresses does count as actual notice, I would say that that may be a factual issue that should also give this court a good deal of hesitancy about addressing the forfeited constitutional claims. So I think for all of those reasons, the court should not address that facial due process challenge. Shell Point also addresses the content of the notices. But again, if you look at pages 189 to 192, the notice of foreclosure sale, that does not include the subject to language. And even if it did, Shell Point's argument is that the district statute doesn't require notice to other lien holders, or at least it didn't as of the time of this sale. The content of the notice is not a reason to invalidate the district statute. That is not included in the district statute. So I think for all of those reasons, and because, as I said, I think the takings claim has now been abandoned, unless the court has any further questions about that, we would ask that you reject the constitutional claims. Thank you all very much.
Council, when you're ready.
Thank you, Your Honor. I would just briefly say to go back to the summary judgment order. Regardless of any procedural improprieties with that order, the trial court just got that wrong. One of the findings that it made was that Tyroshi, quote, undoubtedly believed it was purchasing the property subject to the deed of trust. While there doesn't seem to be much question that, at least among the parties, that it was announced at the sale, if the court would turn to AA 146, paragraph 72, in its answer, Tyroshi denied that the property was marketed as subject to the deed of trust. So the court said that it reviewed the record, but clearly it missed that point, and there wasn't any contrary evidence supporting its finding that Tyroshi was under that belief. Perhaps Tyroshi showed up late, maybe the member wasn't paying attention. But in this case, that's a judicial admission as to that point that that property was not marketed subject to the deed of trust as to him. Like, he did not believe that the property was subject to the deed of trust.
And I see that in the motion to alter or amend, this point is made on page 318. The only evidence in the record as to those circumstances reflects that Tyroshi did not believe it would be taking its interest in the property subject to the mortgage. So that seems to me a pretty strong indication that before the trial court, New Penn Financial was not making this mutual mistake of fact or law argument that has been discussed at the bench today. Is that fair?
That's fair, Your Honor. But I will say, I mean, mutual mistake, there was a mutual mistake in that Brandywine and Shell Point both believed that the property was being sold subject to the deed of trust, even if Tyroshi, as a sophisticated real estate investor,
I'm sorry, did you say
Believe
Shell Point
otherwise.
believe that?
I thought Shell
or
Point,
sorry, Bank of
Bank of
America
America.
or Shell Point's
So Shell Point
predecessor.
wasn't even in
Yeah,
the picture.
Shell
though.
Point
They
was
would
not in the picture at the
formally
time.
no beliefs.
My apologies.
but okay, so this is where I'm getting confused, right? Because we have a buyer and a seller. We've got Brandywine as the seller and we've got Tyroshi as the buyer. And the representation is made by New Penn Financial to the trial court in its motion to alter or amend that the evidence actually shows that Tyroshi did not believe that it was taking the property subject to the first deed of trust.
Correct.
And so that would seem to preclude any argument now that there was some sort of misunderstanding between the buyer and the seller. Are you trying to tell me that a misunderstanding by someone else is pertinent to our decision of the equitable claims?
Well, Your Honor, I don't know what Tyroshi believed at the time of the sale, but at least during the litigation, it took the position.
Oh, aren't you bound by the statement that you're saying Tyroshi didn't believe that it was, the sale was subject to the first deed of trust?
Well, that's what Tyroshi said in its answer. Yes.
It's what Tyroshi, you're saying what Tyroshi said in its answer, and then, there was discovery and litigation, and then in the motion to alter or amend, you took that position, or
Correct.
your client took
And,
that
and Your Honor,
position.
it's a little bit less of.
So, but my question is, so as between the buyer and the seller, I'm struggling to see the misunderstanding that relates to what we were talking about, another equitable grounds to set aside this sale. Are you saying that there's a misunderstanding by a third party that should bear on our consideration of unwinding the sale?
Yes, Your Honor, we never really raised the argument of mutual mistake. We raised somewhat related considerations of just mistake, misrepresentations in general. And the fact that it was announced at the sale, whether Tyroshi later denied that, would have affected other bidders at the sale and would have chilled bidding. So it's more of a surprise as I believe it
As
was
to third
Fitzgerald.
parties
Correct.
and, okay.
And as to potential bidders at the sale, preventing them from bidding on the property.
And was that briefed before the trial court in the motion to alter or amend?
Which portion, Your Honor?
The surprise by as to third parties?
I don't believe they specifically use the term surprise.
Are any cases, is that elucidated in any way? And I mean, the motion to alter or amend, the discussion is 3 pages long.
Correct, Your Honor. Not in the motion to alter or amend. I will say it did talk about the misrepresentations and chilling bidding in the original opposition to the motion to dismiss.
Okay.
Looks like I'm out of time. So unless you have any other questions,
Thank you very much.
thank you, Your Honor.
Thank you, counsel. We appreciate your time today. We know we kept you in court for a little bit more time than was scheduled, but we really appreciate your advocacy. Thank you. Next case on our calendar today is 20 CV 556, 1417 Belmont Community Development versus the District of Columbia. Counsel, when you're ready.
Thank you, Your Honor. May it please the court, I'm Mike Cassell.
Hold on just one moment. We'll wait for the door to close because it's a little loud. Thanks. Can we make sure the door is closed? Thank you. All right, I think seems to have died down now. Thank you for your patience.
Thank you, Judge. May it please the court, I'm Micah Salba, I represent Belmont. I'd like to reserve 4 minutes for rebuttal. Your Honors, when the district government destroys a property owner's building without providing notice in the specific manner prescribed by enrolled law, the government has breached the property owner's due process rights.
Can I just ask you, that seems very broad. So, imagine the district had a, obviously silly statute which said that notice has to be, provided in a calligraphy, if that's a word, notice on, heavy paper and, gold leaf. And the district didn't do that. But it gave, perfectly good notice in any rational sense. You're saying that it's a violation of the federal constitution, whatever process the district says notice has to follow immediately without more, if not followed, is not only a violation of district law, but also a violation of the constitutional due process requirements.
Yes. As silly as the court's hypothetical is intentionally, the notion of due process is fundamentally what process is due. How do we know what process is due? Well, if there's no statute that defines due process, then it boils down to a sort of a complicated and very thoughtful analysis of whether notice has been properly delivered, or adequate notice rather, and whether the party had an opportunity to be heard. But when due process, when the process that is due is laid out in statute, it must be honored specifically. Now, how do we know this? We know this because this court and the DC Circuit have held that repeatedly. I find it really interesting that in
I suppose you're talking about, is it Associated Estates v. Caldwell? That's sort of your main case?
Yeah, Associated Estates was
in which the word constitution does not appear. The phrase due process appears, and it says that strict compliance with a tax sales statute is required in order to guard against deprivations of due process. It doesn't say that a lack of strict compliance is a due process violation. It sounds more like it's a prophylactic rule. So your best case so far doesn't quite say what you needed to say. Well, what else do you want to point me to?
respectfully, Judge, I disagree. I think
Tell me where.
If you look at the precise language of the case, it's true, it doesn't utter those words, but I don't think it needs to. Particularly if we look backwards.
I think it does need to. That's not a due process or constitutional violation kind of case. It's one thing to say, look, there needs to be strict compliance with the district's statutory notice requirements before you can raise a building. And if you had filed an injunction prior to the raise here, court might have issued it and say, yeah, that's right. Strict compliance requires that. I'm not going to let you raise the building. It's a quite different thing to say, and having already raised it without strict compliance, that is a constitutional violation of my due process rights, where the case law generally says all due process is required is not even actual notice, but a reasonable attempt at notice, to which you might say, posting a notice on the site for several months and mailing it to your client is reasonably calculated to achieve notice. So that's usually the standard for a due process requirement.
No, Your Honor.
I mean, you can say no, but tell me what case you have that says failure to comply with the statute equals a constitutional violation of due process. And if you're going to point me back to Associated Estates, you got to tell me where in that case you think it says that.
Well, I'm not going to quarrel over Associated Estates because we don't need to. Though I think that when the court says due process, they mean constitutional due process because there is no other type of due process.
Yeah, no, I agree. I agree that they're talking about constitutional due process. They're just not saying that it's a violation of due process not to strictly comply with the statute.
Okay, but let's go back. Let's look at Body. Body was the case on which Associated Estates relied. There was a misaddressed envelope. The mail carrier recognized that the envelope was misaddressed, delivered it appropriately to the person it was intended to go. And the court held that it did not satisfy due process because the envelope was misaddressed. Let's go backwards further to the early case, right? This was the case on which Body versus Carkenny relied. 1853. The United States Supreme Court says an individual cannot be divested of his property against his consent, that's divested by the state, until every substantial requisite of the law has been complied with. Now, all of these cases are drawing their power from the due process clause. They are not saying, hey, we're judges, we get to decide just because it's our opinion, just because we're judges and we're really smart, exactly how the due process rules, or rather the service rules, have to be complied with. After all, in Body, we know that the notice actually got there.
Can I ask you, it just seems like that's a sweeping theory, and at its broadest, it is whatever process the state chooses to give you, even if the Constitution wouldn't require the state to have given you that process, any deprivation of that process is unconstitutional. Is that seems like the logical structure of your argument, and that would mean that, take your pick. If you have 14 days to respond to a motion under the DC rules, and you're only given 13, that's just not a failure to file the district's procedural rules. It is a constitutional violation. It just seems like that's a quite sweeping doctrine.
Your Honor, I agree with you that it's shockingly sweeping, but it is also the firm law of this court. There was a case, and I'm sorry, I can't remember the title because I'm getting old, but there was a case where somebody had 82 days of notice and they were supposed to have 84. Wasn't enough. It did not meet constitutional due process. I suppose that's redundant. It did not meet due process requirements.
So, counsel, say there's some sort of process issue. Supreme Court considers it and says, this level X is what you need to satisfy the due process clause in this context. And then the DC Council comes along and says, well, Supreme Court said you need level X, but that's kind of skimpy. We'd like to give people more process. So we're going to write a statute and give everyone X+1, right? Now it's in a statute. But the Supreme Court said all you need is X. Are you saying that by virtue of enacting the statute that gives people X+1, suddenly that is what due process requires, and that the DC Council has legislatively overruled the Supreme Court?
Forgive me for picking on your hypothetical, but the hypothetical is flawed slightly, because the language that the Supreme Court likely would have used would be minimum due process. Minimum due process is X. That never stops a government, the elected leaders, right, from setting a higher standard. Now, it's sort of interesting if we look at Stewart versus Moskowitz, where this court said strict compliance is necessary before the government can take property. Strict compliance. Substantial compliance, not enough. Strict compliance. This court then went on and said, even if we didn't have the statute, we would get to the same result. Why? Because then we would look at due process sort of separately. Was due process met? We know that if the statute is met, if the requirements stated in the statute are precisely met, then due process is met, because due process means just that. What process is due? And in an
But is
employment
that,
case.
I didn't know you were taking the inverse position as well. So if a statute is for any raising of a building, the city must tie a notice to a carrier pigeon released within 3 miles of the intended recipient. Due process has been complied with? I mean, I understand you're saying it needs to be, you have to comply with the statute, otherwise you violated due process. But what you just said is, and if you have complied with the statute, you've satisfied due process, which seems to me equally sweeping and clearly wrong. Because you could have an absurd statute that is not reasonably calculated to provide notice to somebody. You shout it out through a bullhorn in the, by the Washington Monument at noon every third Thursday, whatever properties are going to be raised. I doubt that would be reasonably calculated to provide notice, and I doubt that would satisfy due process, even if a statute said that.
Right. Because I'm in the habit of quarreling with hypotheticals, I'll say, since I'm a beekeeper, if you use bees instead of birds, it would definitely work. It would be fine. But your hypothetical is birds. And I agree that in that hypothetical, we've got a means of notice which is not reasonably calculated to provide notice.
Okay, so it's not coterminous with a statutory requirement. You're just saying that a statute provides a floor of due process, not necessarily satisfying due process.
So I'm a little worried to say that only because if we read the cases and the literature, we see that specific word coterminous used all the time. But I agree with you that if the means prescribed by the legislature are not reasonably calculated to provide notice or an opportunity to be heard, then it would not be adequate. In that case, the lawsuit would not be Belmont's suit. It would be a different case in which somebody's facially challenging the law. Somebody would say, hey, legislature, you're claiming that this satisfies due process, but it doesn't. It cannot. So it is possible to attack the.
I'm going to try one more time. Give me your best case where we or some precedent has held it to be a due process violation not to provide notice as required by the statute. And I want to disentangle two threads because I think you're combining them in a way that's not quite right. It would be one thing, which I think we've said, usually in tax sale cases, to say we're not going to allow that sale to go forward absent strict compliance with the statute. Why not? Well, it raises due process concerns, your deprivation of property without due process. And so we just want to be extra sure you're complying with the statute. And those are sort of prospective violations where the courts are saying, we're not going to let the sale happen because we don't want to raise a constitutional problem. We don't want it even to come up to us. But what's the case that says where the sale has been completed, where the raise has occurred, and there's not been strict compliance with the statute? All the cases I'm reading, like Milani, say, well, you look at whether or not notice was reasonably calculated and it doesn't even need to actually be received by the interested party. Just was it reasonably calculated to get there? I don't see any that say it's a due process violation not to follow the statute. What's the closest language you have to point me to?
Your Honor, I respectfully, I think that you're confusing two different bodies of case law.
That's what I think about you. So tell me what.
There's the body of case law that deals with what is due process, what is adequate due process. There's a separate body of case law that says when there is a statute, it has due process been delivered. In each of the cases that I've described, including Associated States, the courts have been clear that when the legislature lays out a law regarding how notice must be delivered, due process demands that that notice be delivered in that way.
Your opponents cite, for the contrary principle, some decisions of the DC Circuit. And they quote, one of them says, the fact of a state law violation does not resolve whether a plaintiff has been deprived of due process. You think the DC Circuit's just wrong about that, I gather, or at least contrary to what you understand to be our law.
No, I think that my colleague is wrong in describing the case. The case
This is
doesn't
just a
say
quote.
that.
This is a quote, so maybe they're misquoting, but this is a quote of theirs called from a case called Barwood on page 41 of their
Right.
brief, where they say the fact of a state law violation does not resolve whether a plaintiff has been deprived of due process. And then there's another quote from an old Supreme Court case that says mere violation of a state statute does not infringe the federal constitution.
That is correct statement of law.
The second half of it. You mean the second of those two quotes or both of them?
Well,
Because of a compound question, the way I asked it. So I apologize.
yeah, objection, Your Honor, compound. I'm not sure I can, I would presume that both of those quotes are accurate statements of law. The problem is how the government seeks to apply that statement of law. It is true that the violation of a statute does not itself make a due process violation. So in this case, these poor
But I thought
taxi.
your position was, that's why I was wondering how narrow or broadly you were pitching your argument. I thought your argument in this case was if it's a state statute that governs process, then the violation of it does constitute a violation of federal constitutional procedural due process requirements. Am I misunderstanding the scope of your argument, or is that a correct description?
No, I'm probably not communicating well. Due process requires two elements. Number one, there has to be a substantive taking, a substantive denial of a property right.
Fair enough. That's a fair qualification. So in a context where there is a constitutionally protected property or liberty interest at stake, and therefore the protections of the procedural due process clause are applicable, your view is, if I understand it, at least there, whatever state process is afforded may not be adequate, but if it is constitutionally required if the state chooses to provide it in that setting. Is that a fair description of your argument? So again, in a setting where I take your point that if there's a state procedural protection that isn't in an area that implicates property or liberty interests, and therefore the constitutional procedural due process principles are not implicated, then it doesn't matter as a matter of federal law what the state has chosen to do or fails to do about what it said it would do or was going to require. I take that point. That's a fair qualification, but I just still trying to figure out the scope of your argument.
So we can
assuming we're in that universe.
Sure.
So what's at stake is a liberty and property interest, and
Right.
the state says, calligraphied invitations on, an 18-point font. You say the federal constitution requires that.
Right. So in the Barwood case, we saw a situation in which the taxi drivers were deprived of a constitutional right. The district violated the law, but the district didn't violate the due process part. So in this case, in our case, the district raised Belmont's building. It is irretrievable. It is gone. The district essentially took Belmont's building. There's the substantive, the taking of property. The district also, because it was required to, attempted to deliver notice. So you got two parts there, the taking of property and the giving of notice. The Barwood plaintiffs said, hey, you guys broke the law by imposing this rule, and I don't remember what the rule was, but by imposing this impermissible rule, and now we're going to claim that that's a due process violation. The court said, no. There was no violation of the notice part of this. There has to be both. Barwood says—
But your point is not limited to notice, if I understand it.
I'm sorry?
Your point is not limited to notice, if I understand it. It's whatever process, if we're in a world where the state is depriving somebody of an interest, the property or liberty interest that's protected by the federal constitution to the extent of triggering procedural due process rights. I took your point to be whatever process, not just notice process, but whatever process the state chooses to provide in connection with that deprivation, the state is constitutionally required to carry through on its promise. No matter, it's not limited to notice, your point. It's whatever process the state offers, says as a matter of law, it's going to give to people with respect to whom it's going to deprive them of interest protected by the federal constitution. If I understand that, is that right? Or
That is
did you have a
correct.
specific theory about it?
There's plenty of room to challenge state impositions. There are some states that wish to impose greater restrictions to handcuff itself more before taking certain action.
And
right?
the reason I asked you about the scope is there's a line of Supreme Court cases which your opponent hasn't cited that arise in the criminal setting, where for sure someone's liberty interest is at stake. And states provide all sorts of process as a matter of state law to criminal defendants. And there's a line of Supreme Court cases that says, well, a violation of those state procedures isn't of itself a violation of the federal constitution. There has to be something more. And that, like, their peremptory challenges are an example where the state will say, and if you're a criminal defendant, you can have X peremptory challenges. And if the state in a trial doesn't carry through on that, it makes a mistake and then gives people the wrong amount. That's not treated as in and of itself a federal constitutional procedural violation, because what is said is that's an issue of state law, and state, if they choose to give more process, then there's a paraphrase. I'm not purporting to quote, but the logic of the cases, as I understand them, is the state chooses to give you more process and they don't carry through. That might be an error of state law. You may have an entitlement to get relief in state court, but that doesn't mean you're going to get relief in federal court as a matter of a federal violation. Now, it's a little tricky that there's some complications, but it just seems like the logic of your argument, especially if it's not tied to notice, and I don't know why conceptually it would be, the logic of your argument seems like it would lead to a lot of consequences that are different from the way the law seems to operate. So that's why I'm puzzled by it.
Well, look, the bench is pressing me on the limits of this principle. The principle is,
I guess I apologize for interrupting. I understand myself to be pressing you on the existence of the principle, not just its limits. I'm just not sure. I think there is a principle that state law process, if violated because the state chose to give it in an area where the procedural due process applies, is transformed sort of just by operation of those two facts into a constitutional violation. So I understand myself to be questioning whether that doctrine in that form exists, because I'm not sure that it does.
so when the Superior Court first decided this case in 2016, Judge Rankin issued a lengthy, detailed, and careful opinion. And he came to the same conclusion that I'm coming to, which is that when the state says, this is the notice to which you're entitled before we take your property, the state will be held to that promise as a
Well, for
matter
sure,
of constitutional law.
I mean, the state will be held to it in state court. Whether it'll be held to it as a matter of federal constitutional law is a little less clear to me. I understand that you're right that Judge Rankin believed that.
Sure.
I agree with that. Judge Rankin did say that.
State courts are not at liberty to ignore due process restrictions. And it was not uncommon for state legislatures to set rules of process that were inadequate to meet the notice and right to be heard standards imposed by the Due Process Clause. Think of the South. And those rules were inadequate, so they were not permissible. There is nothing to stop a legislature from imposing stricter rules. And because the state makes a promise to its citizens, it sets expectations. I feel like I'm arguing the previous case, right? It sets expectations. And you are entitled to the notice which has been promised. You are constitutionally entitled to it, because the state cannot make a promise to provide notice before a taking, right? We're not talking about all sorts of laws that the state can break, and if you've got damages, you claim injury and you file a lawsuit. We're talking about this specific realm of before the state exercises its power to take property from a property owner, it must give notice. That is a bedrock constitutional principle. And when the state says, this is the notice to which you are entitled, the Constitution requires that be honored. Now, I understand that Judge Deal, you've got some skepticism about that, but each of the cases that I've relied on are bound, are footed very firmly in this constitutional rule of due process. They're not simply saying, well, the state says we'll do this and, it's good public policy. This court is not involved in public policy. This court is involved in what the law says. And that is precisely what the courts say here. There are, in fact, many cases where they say, our focus is not on what's right or wrong. It's on what does the statute require. And this, again, I recommend Stewart versus Moskowitz, but also the early case, both of which focused on that. The right to notice is fundamental, and the notice that is required is that which is stated in law. Let me illustrate this with one more case.
But one more, because we've kept you up here for some time. and-
Yes, Your Honor.
Yeah.
In Thompson versus the District of Columbia, there was a dispute over whether the District of Columbia had to extend any notice rights to the plaintiff before firing him. The plaintiff had been a civil servant. DC changed the law to allow termination at will. The relevant action occurred before that change in law. And therefore, he was entitled to notice. The notice he was entitled to was defined by statute. If the statute says you are entitled to notice, and here's the notice you're entitled to, then the state must deliver that. And that is not something that any court can ignore or overrule, because that's the bedrock principle of the Due Process Clause.
Thank you. We'll give you time on rebuttal.
Thank you so much.
May it please the court, Tylen Trayer for the district. I'll dive right into this due process discussion. I think as the court's questions indicated, it is quite wrong to equate this state statutory requirement with constitutional due process. The general rule is that the two are not coterminous. And that flows in some ways from the general rule also that due process is a flexible rule, requires only notice reasonably calculated under the circumstances to reach the individual. Due process does not, as the panel noted, does not require actual notice, but notice reasonably calculated. But I'll also note here that there's no genuine dispute based on the record that was before the trial court that Belmont did not actually receive notice. Although Belmont made some assertions in its pleadings to that effect, there was no evidence in the record supporting that assertion.
How would one support that assertion? I didn't receive notice. What kind of evidence can they provide of that?
A declaration, an affidavit, and so
that seems like an awfully formalistic distinction. If you've got, it's true, I guess, that somebody. Do they need to get everybody that is affiliated with Belmont to sign that declaration?
No, I think they could have very easily gotten the owner, Mr. El Taib. They could have even answered an interrogatory to that effect, but at page 74 of the appendix, the statement of undisputed material facts very tellingly omits any citation to evidence in the record. And actually Belmont admits as much at page 252 of the appendix in their reply to the district's response to Belmont's statement of undisputed material facts. But of course, even setting that aside because actual notice is not required, Belmont decidedly had notice here satisfying constitutional due process requirements that if it did not correct the dangerous condition posed by its building, that the building would be razed. There's no fewer than 5 ways that Belmont received explicit notice of this, both in writing and through verbal instruction and interactions with DCRA over the course of 2 years. And also keep in mind that the board had been condemned. The same problem persisted from the beginning of the project through the time that the building was authorized to be raised. We're talking here about a shell of a building. The entire interior had been demolished. We're talking about 40-foot walls that are at risk of spontaneously collapsing on the public in a dense urban area. And Belmont was told, again, in person by the chief inspector, that if it didn't shore up these walls and make this structure safe, that of course the government was going to have to take down the building itself. So there are no.
Counsel, so in your narrative account, you mentioned that this is happening over the course of years, and I guess that's part of what gave me pause, because it seems like there's a lot of conversation between the district and appellants, where the district is saying, you need to take care of this. Appellants are saying, yeah, we will, or yeah, we did, or, here's, we've shored it up sort of, and, then that's not adequate. And then the district comes back to them. But there seems to be this ongoing conversation where the district, and not to belittle their actions, but is, sort of finger wagging and saying, you need to do something, but there's never sort of the final of this is going to be raised, tomorrow, this is happening, right? And so under those circumstances, do we have sort of more concerns about notice? Because it seems like there's an ongoing conversation.
No, and I think the lawful process for the district to correct this condition contemplates that sort of conversation. And there is process through condemnation proceedings. And in some ways, I don't think it's fair to penalize the agency for making its best efforts to work with Belmont to safely complete the construction. That was Belmont's goal, supposedly, or to work with Belmont to take the building down. I think it's always the agency's, it's the last course of action for the agency to have to move unilaterally to take down the building. But also the condition of the building didn't materially change during this time, and the instructions from the agency were consistent throughout this.
Part of the building collapsed during the period.
Well, in the sense that it didn't materially change for the better, Judge McLeese. So that's absolutely correct, that there was in May 2008, a serious collapse that injured a construction worker, and there were 2 other collapses at the site. And so Belmont, was reactionary in some ways in response to DCRA's, I'd say more than finger wagging instructions to make sure that these buildings would be properly shored up. Belmont, at the time, the agency thought erected sufficient emergency stabilization, but that turned out to not be the case, as subsequent collapses further demonstrated. And so you had not just mailing by regular mail, posting, the in-person conversations, the condemnation order, all of these things indicate that under the specific facts presented here, under the totality of the circumstances, Belmont absolutely had fair notice of the action that the agency was going to undertake to get rid of this public safety emergency. And so there was notice of the raise specifically, and also all of the ways that I've outlined that Belmont received notice of the raise satisfies due process. So it will be very easy for this court to resolve this case simply by deciding that there's no predicate constitutional violation. I would also like to point out that I know that my friend on the other side points to the Miller case and the Miles case in its briefing, but those cases are quite distinguishable. And actually, to your point, Judge Easterly, the Miller case contemplates a course of dealing over 18 months there in terms of a conversation between the agency and the property owner. But those cases presented facts that were quite distinguishable. The final communications from the agency in that case told the property owner to keep the agency abreast of further developments. It was fair to assume from that sort of communication that the agency had sort of recanted its position in terms of whether or not the condemnation would actually move forward. And again, I think it is worth emphasizing one more time that we have 40-foot walls that are not properly braced and no further action is being taken, no further construction at this site by the time of the notice of violation. So certainly it stands to reason that the condition would become more dangerous.
Yeah, do you take that to be an undisputed fact in the record that's before us, that there was nothing between March and July of 9 to remedy the situation?
I haven't seen anything in the record that there was any action taken after March. And I think there's evidence in the record that Belmont's engineer did not return to the site. Baral, that's correct. Baral, who was Belmont's engineer, who had told Belmont, who testified that that he agreed with the agency's engineer that the building was unsafe and needed to come down. And so Belmont was on notice to that effect as early as 2008. And so I think, as I indicated, it would be very easy for this court to resolve this case and affirm the Superior Court's grant of summary judgment on due process grounds. I'm happy to answer any questions about final policymaker liability. I guess I would just quickly point out there that my friend on the other side has waived any argument with respect to Director Argo's involvement in any decision regarding notice, has also waived any argument with respect to a decision that she undertook with deliberate indifference. Their sole argument is that they are not required to provide any evidence of deliberate indifference, but of course that runs contrary to the Supreme Court's cases on final policy maker liability. And it is incorrect, moreover, to focus exclusively on the decision to raise as opposed to the decision to provide notice for multiple reasons. I think primarily because the constitutional injury alleged here is a procedural due process injury, an alleged lack of notice, but for all the reasons described.
Well, I mean, there is no violation by virtue of simply the lack of notice. There had been no notice, no constitutional violation, so long as there's not a raise, right? They would have no complaint. They've not been deprived of property without due process of law absent the raise.
That's right, but the locus of the real gravamen of their constitutional injury is supposedly a lack of an opportunity to know that the government was going to undertake this action and to object at the right time. So it's really the notice that is the direct cause of the injury. And the Supreme Court's cases are quite clear that Monell requires officially sanctioned conduct by the municipality. It requires deliberate conduct, a deliberate choice such that the municipality can be considered culpable. And Belmont simply has adduced no evidence to that effect.
Well, what's the evidence of what Argo knew or didn't know about notice prior to directing the raise? Is there a reason to think she inquired?
They haven't pointed to any evidence that there's reason to think that she inquired. And I think that argument equates to the argument that mere negligence could result in municipal liability. And we know that's not the case, as the Supreme Court has said over and over again, I think specifically in Bryan County, that mere negligence.
I'm not sure it amounts to mere negligence. It's a constitutional violation to deprive somebody of property without due process of law. And if you say, at some point in time, I'm going to take away your property without any inquiry about whether or not due process has been provided. It seems a little bit artificial to me to sort of try to dissect the notice aspect of the violation and the deprivation of property part of the violation. The violation is you've taken away their property, no notice has been provided. You didn't provide notice. You had no reason to think anybody else provided notice. Why isn't that enough?
Well, there was also no obvious reason to think that notice would not be provided here. Belmont had, I think, over 4 years of discovery to adduce any evidence of, a series of actions by subordinates, that some kind of practice by the agency, something that would have put the director on notice that she was disregarding some known or some evidence that this was such an obvious risk that the failure to inquire would obviously result in a due process violation. I actually think that there's at least two reasons why there would not be deliberate indifference there. I think as a matter of just, strictly, causal relationship, what would be the obvious outcome in terms of a series of events? It wouldn't have been obvious absent anybody telling her any reason to believe that would be an obvious outcome, but also it's not obviously a due process violation.
I guess maybe this would depend if this were load bearing on who has what burdens. But it seems to me that depending on what, if anything, Director Argo had in mind or asked or generally knew about what was supposed to happen, her conduct in signing off on the raised permit, again, assuming that there was inadequate notice, could have been all the way to deliberate indifference. It would depend on what she knew, what she asked. So again, if someone just comes to me out of the blue and says, I'd like to rip down a building in the District of Columbia, and I'm a District of Columbia official, and I don't really know anything about what has happened up to then, and I say, sure, go ahead and rip down the building, and I haven't asked, like, well, did you give anybody any notice you were going to do that? That could be deliberate indifference or worse, right? It would seem. Even if it's within my authority, if literally I have no knowledge about what the general procedures are that would be followed, I have no reason to believe notice was given, I don't ask. That seems like at least a reasonable person can think that would be deliberate indifference if those were the facts.
Well, perhaps those aren't the facts, and that's because this is the director of an agency who, just like courts, is entitled to rely on a presumption of regularity that her subordinates are going to comply with the law. There's
fair enough. I mean, perhaps assuming that the director knows that there are laws that her subordinates should be following that would provide notice, then I think that'd be a good set of points. But again, we don't know any of that. And that might wrap around who has what burdens, because it's not like we have allegations from your opponent about any of that, but we don't really know. And this is part of Judge Deal's question. We don't really know what Director Argo asked, didn't ask, knew, didn't know, presupposed about what her subordinates would or ordinarily should or were required by law to do by way of notice. We really don't know anything about any of that.
Well, that is their burden to advance and prove their theory of municipal liability, and they specifically chose to rely on a final policymaker theory of liability. So they could have also tried to adduce evidence of an official policy, of a custom, and there's also multiple ways that they could have tried to prove a final policymaker liability through knowledge, through express ratification of the subordinates' actions, that she should have been aware that this was a problem within the agency. So these are all the different ways that Belmont could have attempted to prove its case. But over 10 years of litigation and over 4 years of discovery, Belmont can point to nothing. And so for that very simple reason, there can be no final policymaker liability here. The court has no further questions. We ask that you affirm.
Thank you. Mr. Saab, we'll hear from you.
The District of Columbia is flat out wrong in raising deliberate indifference. Deliberate indifference applies solely to actions taken which do not themselves cause constitutional injury, but which have a downstream effect. I've laid that out in my brief. The district hasn't addressed that. Deliberate indifference does not belong in this sort of case. Second, the passage of 2 years of discussion and debate between the district and Belmont is enormously important here, because Belmont had been working with the district for a long time to solve this very difficult technical problem associated with this building. 2.5 months passed between the notice that DC gave and when they raised the building.
And what's the evidence about what your client did or heard from the district during that period that might have been relevant to whether there was adequate notice?
Well, I don't believe that there's any evidence indicating that there was any further notice, meaning something other than colloquial. Were there discussions? Sure, but that is not notice.
Perhaps, but again, one way of looking at this is if the district sends you a notice of violation, your client, a notice of violation that says this is a dangerous building, We have the authority to rip it down at any time. You need to fix it immediately. If you don't, we're gonna, send it off to people who enforce these rules. If that was the original notice. Then part of your point, and a point that the trial court gave some weight to, was, well, there's things that happen, things happen. That's not an absolute decision to raise. That's a threat. That's an assertion of the right to raise. And that one of the points the trial court made was, well, later there's a decision to raise. So that's one line of the trial court's thinking. And just focusing on that for a minute, do you think that it's a federal assume that notice had been given in the right form? But what was said substantively in the notice was, there's a condition in this building that authorizes us to raise it. We have the right to raise it. If you don't fix it in 10 to 15 days, in 15 days, wherever the number was, we may choose to exercise that right.
Well,
If that were the notice, just assume for a moment that's the notice.
Well, the notice actually was.
I'm giving you a hypothetical, so answer the hypothetical, and then you can, if you want to
No, I
debate
appreciate
the
that.
relationship between the hypothetical and the
Right.
and the real situation, that's fine. But imagine a hypothetical. I'm trying to illustrate a legal principle with a simpler scenario.
Sure.
So assume then what happens is that 3 weeks go by and a decision is then made, we're going to raise it. Hadn't been previously made. Do you think the Constitution would entitle the owner of the property in that setting to a separate further notice?
Yes,
And what's your support for that idea? Why should that be true? And what's your legal support for that idea?
because the notice that you just hypothetically laid out did not say we are going to raise your building.
Understood.
Could it happen? Yeah, lots of things can happen. Meteors can fall from the sky, right? The mere fact that Belmont or that this entity is notified that enforcement action might happen does not adequately put them on notice that the district will come in and raise. And we know
Why does the
that.
Constitution, it's just not intuitively obvious to me that the federal Constitution requires that you be told a definite decision has been made to take away your property, rather than that there's a condition that authorizes us to do it. We're considering doing it. If you don't fix it, you're subject to our doing it. I just, it's not obvious to me one way or another. That's why I'm asking you, do you have legal support for the idea that the federal Constitution dictates that notice be certain plan to deprive rather than we assert a right to, and if you don't fix it, you're subject to our exercise of that right? Well, it's not obvious to me that the federal Constitution would dictate that.
I'm afraid I can't answer that question as I stand here. I can point out that the actual notice was, hey, you need to raise the building, not we will raise the building.
No, what the notice said, if I recall, was it cited provisions that authorize the district to raise it, and said, if you don't fix it, we're going to refer it to an enforcement entity.
Correct.
Right. So it's definitely less direct than my hypothetical. That's a fair point about the connection.
But the substantive instruction to Belmont was solve the problem or raise the building, not.
Or we'll send it off to people and we assert the right to rip it down ourselves.
Right.
So that's the whole picture.
I certainly think there'd be room to debate whether that constitutes adequate notice, but for the fact that we know that the passage of 2.5 months added to the uncertainty and added to the actual activities of Belmont in that 2.5 months.
And that's what I was asking you concretely. What can you tell me? I mean, I get the picture, and this is a little bit like one of the two cases, maybe Miles, I don't know, but I get the idea that a notice like that could be sent. And then there could be later discussions that are kind of lulling in character. It's like, yeah, you said you were going to rip it down. You have asserted the right to rip it down yourselves, but now you're talking to us. You want us to fix it, and so all of a sudden you go rip it down yourselves after this conversation. We're surprised. I get that line of thinking, but it turns a little bit on the content of what happened during that period of time. And the district's picture about what happened during that period of time is they were trying to reach your folks and you weren't responding, and they were banging their head against an unresponsive wall. That's that's their picture that they paint. What's the evidence in the record that in fact what was happening was something more like the cases where, although there had been a threat, somewhat debatable in its clarity, there had been an assertion of authority to rip it down unilaterally. Then there was sort of conversations that would have reasonably led the property owner to think, That's not where we're headed. Is there anything concrete in the record about the nature of that would support the idea that a reasonable owner would have thought the district is communicating to me that doesn't plan to carry through on that threat?
I'm afraid that as I stand here right now, I'm not able to point to anything in the record. My understanding is that Belmont was working on solving the problem, was working with the District of Columbia, which makes the ultimate raise decision that much more sort of offensive, because 2.5 months passed during which they're working on solving these problems. They did not have timely notice of the raise. But there are, I know I'm using more than borrowed time, so there are 2 other points that I'd like to make, if I can be indulged, in response to my colleague's comments. The first is the notion that effective notice is enough for due process standards. It is impossible to synthesize that assertion with the many cases that say, even when notice, excuse me, even when notice is delivered, if it's not properly done, it is inadequate. As a taxpayer, I don't like that. But that's the law. Is it wasteful of government resources? Perhaps. Is it somewhat illogical? Perhaps. But it's still the law. Also, the district has made several noises about all the activity over 2 years preceding, and also about the safety issue. But the district never acted according to its authority under the safety regulations. It was a section 3103 on which they acted, or 01, with the notice provision being 03. And that was not about imminent danger that we must immediately solve. Could they have done so? Yeah. Finally, the district, sorry, I just lost my train of thought. The District of Columbia gave notice. The statutes, as I laid out in my opening brief with the table, laid out a host of different ways of providing notice. The district had in the past provided notice with the return receipt request. They knew how to do it. They knew what the law was. In this case, they chose not to follow the law, or it was inadvertent. Either way, they didn't follow the law. The law also says if notice is not effective, here's what you can do. And there's another set of rules. In this case, they didn't have a green card because they never asked for a return receipt. They could have, they should have, the law required it, they didn't do it, but nor did they then follow up and make sure before raising the building that they had met their due process requirements. The due process clause says before you take property, you got to make sure you've provided notice. They tried to provide notice. They didn't do it in the right way. They cannot meet their burden to prove that they gave correct notice, or even that they tried a second time. And for that, they violated Belmont's due process rights. And the Superior Court decision should be overturned. Now, I know I haven't addressed a host of other reasons. I hope that the briefs adequately address those things.
Thank you, Mr. Saul.
Thank you,
Thank you,
Judge.
Ms. Traer. The case will be submitted. The next case on our calendar this morning is 22 CV 532, Washington Hospital Center Corporation doing business as Washington Women's Wellness Center at Washington Hospital Center versus Shanae Beatty et al. We'll get everyone a few minutes to get situated. Counsel, when you are ready.
Morning, Your Honors. Derek Stegleather on behalf of the Appellant Hospital. The hospital did not get a fair trial because the trial court did not allow it to raise its contributory negligence defense in a case where the patient failed to follow clear medical instructions that would have prevented her death. She was twice instructed to return for testing. She twice agreed to do so, but she never returned, which led directly to her death from an ectopic pregnancy. The trial court erroneously held that this raised no fact question on contributory negligence, that it was reasonable as a matter of law for her to behave that way. And this requires a new trial. But the new trial should not include a claim for informed consent, because the informed consent doctrine protects only those patients who are harmed by consenting and submitting to the recommended treatment without adequate information. It does not protect patients harmed by not following instructions for treatment that they have agreed to follow, but have simply skipped. Complaints about Nurse Belna's communication state claims only for ordinary traditional medical negligence. It is not an informed consent claim. And finally, the $15 million in wrongful death damages that were awarded on top of more than $2 million for lost household services, for lost earnings, and for pain and suffering must be vacated as compensation for non-pecuniary sentimental loss. Such loss is not recoverable under the Wrongful Death Act. And yet, primed by an improper Colston argument and sentimental appeals, the jury here returned a shockingly excessive award for lost parental guidance without a sufficient evidentiary basis. On the first point, and I think the most important point, is contributory negligence, because that is dispositive of the appeal. Patients have a well-recognized duty to follow medical instructions. And we've used words like that, but we also wrote a footnote saying that's not a good choice of words. I mean, they don't have a duty in the sense of, like, if I'm a physician and I tell my patient do X and my patient doesn't do it, I can't sue my patient in tort saying you violated your duty to me to do what I directed you to do. So it seems like it's an imprecise form of words to say there is a legal duty of that kind. And what we said in the footnote, in the case it's not, the name it's not leaping immediately to mind, is not to disparage the idea that it's relevant to a negligence claim that a patient was directed by a medical personnel to do a thing. But we seem to say the duty is not really the right way of looking at it. Do you actually think it's, I mean, do you think we should be writing it as though there is a duty, an absolute duty by a patient to do whatever a doctor tells the patient to do? That seems legally inaccurate and kind of factually extreme. I mean, my doctor might give me terrible advice and I might realize that. So I guess I get hung up on the use of the word duty here. Well, the precedents refer to a well-recognized duty to cooperate, and perhaps, and there are two duties that are expressed. There's the duty to follow medical instructions and the duty to cooperate. And if Your Honor's identified sort of a harshness, and it cannot be absolutely true that there's a duty to follow instructions. That's correct. Patients do have autonomy. They are not wards of the doctor. They're not commanded to obedience. But there is a duty to cooperate. And as even Nurse Belna described, there is a collaborative process that goes on.
So let's stop
Sure.
there with the collaborative process, right? When you collaborate, you have communication, right?
Yes.
And we don't actually know what was said to Ms. Beatty by Nurse Belna, do we? At the time of the first exam?
We don't know precisely
She
what
does
was
a
said.
rapid pregnancy test, presumably a urine test. Is told that she's pregnant. You do an ultrasound. It's abnormal. That's according to the notes.
Yes, and that she's told it's abnormal.
And she's told that it's abnormal. Nurse Belna also testifies at trial. It's not uncommon to have an abnormal ultrasound. It's always something we encounter. You know, sounds like on a daily basis.
Mhm.
And she's told to return for a blood test.
She's told she needs to return.
Well, is that in the notes?
Yes.
Needs to return?
It's in the direct testimony of Ms. Nita Wilson.
Okay.
She
Who-
says,
Who
not
who
only
recalls?
recalls that generally that Nurse Bellman does this, she says, I remember this patient and I remember hearing her say she needs to return.
Needs to return for a blood test.
So this was
But
this.
no explanation of why. Right?
Well, what Nurse Bellna, unlike Ms. Wilson, who specifically remembered, Nurse Bellna said, I don't honestly recall this patient, so I can tell what I normally do. She said, as I'm doing an ultrasound, this was a 15-minute procedure. She says, I continually talk to the patient. I tell her what I'm seeing, and I tell her the different things it could be. And on her differential diagnosis for that day, she has a 4-point differential diagnosis. And
Right.
one of the four is ectopic
One is
pregnancy.
you're not actually pregnant,
Certainly,
right?
yes,
2 is you were pregnant, you
Yep.
had a miscarriage.
yep.
3, you might have an ectopic pregnancy. No indication if she explains what that means to the patient, right? What's 4? I can't remember.
4 is the remains of I forget the exact terminology, but essentially it's remains of a procedure, or I don't know if it's whether sort of a partial abortion or remains of conception, but essentially it's
Some other biological
Yes.
materials floating around.
yes.
Right? But essentially, she's saying it's abnormal. We don't know why.
Mhm.
Lots of different reasons. Right, so that's in the course of the exam, and then says you need to come back for a blood test.
Yes,
No explanation of why. No explanation that there might be a life-threatening condition. Correct? Right, so if we're talking about collaboration and communication, and you're a patient, and you're a working mother, and you have 3 children, and you go in for an ultrasound, and they say it's abnormal, and the nurse even says, happens all the time. Lots of different reasons that there might be. I told her there were lots of different reasons that there might be. I even told her, or I did not tell her that it could be life-threatening. I didn't want to scare her, right?
Mhm.
So I definitely didn't tell her that.
Mhm.
In the context of communication and collaboration, why is it that Ms. Beatty suddenly had a duty to jump when the nurse, or to say how high when the nurse said jump? I mean, I'm not following here the duty to cooperate
Well-
when the obligation has not been explained, at least according to the record that we have here.
Well, the record allows the inference that it wasn't explained. It's quite possible that in giving her explanation of ectopic pregnancy and during a 15-minute conversation, there is discussion about it, but it's not.
The evidence came
it's
in as
not-
the evidence came in, right?
Correct, and the evidence
Yeah.
was that I tell the patient what it is and what it could mean. So it's not ruled out, but we'll go on the premise that she
I
did
mean,
not
we are
say.
taking the record right now, and you are saying, as a matter of law, you are entitled to an instruction on contributory negligence
Definitely.
based on these facts.
Definitely.
So you have to take these facts, not the speculative facts that in fact the patient was told more than what's in the record.
Well, what you're entitled to as a matter of law for a jury instruction is if there is any evidence that supports your theory of the case. So it's not like
Okay.
a summary judgment where you clearly have won. Although I think under these facts, there could be summary judgment that this is contributory negligence as a matter of law. Because
Can I ask
she
you
is-
about any evidence? Because I get hung up on that. I
Sure.
mean, there's almost always some evidence supporting any side of any case. It's pretty hard to zero out evidence.
Correct.
And so there are sometimes we use that word, but there are other times, and sometimes some of those cases are in criminal settings
Mhm.
where the burdens are, where it's a defendant seeking the instruction and the burdens are very high on the opposing party. But in civil settings, we more typically or often use words like some, and sometimes we say basically it has to be evidence from which a reasonable fact finder could find in favor of the party seeking the instruction.
Mhm.
Do you really think we should be looking to see whether there is any evidence, even if it's a scintilla, or do you acknowledge that it's something more than that? And where do you draw the line if there is a line and distinctions in your mind among formulations, one of which is, was there evidence from which a reasonable fact finder could have found in your client's favor on this issue?
I think that's a better articulation, the reasonable juror standard. But here, we're so far past mere scintilla, or what Maryland calls meager evidence. This is a patient who is twice instructed. You need to come back, not I recommend it, you should think about it. This is-
Can you remind me what the evidence was about you need to come back within timeframe X?
She.
I know she had scheduled blood work for 48 hours later. Was there anything communicated that 10 days wouldn't be fine?
No, she was told you need to come back in 48 hours. There's both the testimony from Nurse Belna and the assistant who specifically remembers her saying that repeatedly, that she needs to come back in 48 hours.
And so I can understand concluding that a patient is unreasonable for failing to follow a doctor's instructions like that. But one argument Beatty is making is, but they need to be able to apprise the particular risk that they're disregarding. So maybe they're unreasonable because maybe she could lose the pregnancy if she doesn't. And maybe she was unreasonable because maybe her blood pressure could be too high and that could lead to complications. But there is no reason for her to apprise a risk of death from you need to come back in 48 hours. And a reasonable jury can conclude from that she would apprise a risk of death. So I have two questions from that. Do you think there is evidence that she should have been able to apprise a risk of death? And do you think that's a necessary showing for a contributory negligence instruction?
I think what's crucial to understand first is she was twice instructed. She didn't show up and then was reached by phone by the doctor, by the nurse practitioner who said, you need to come in tomorrow. So that is an exceptional fact pattern that we have here, where that, if not the initial point that being told by your healthcare provider, you need to come back in 48 hours. I think that under controlling precedent, that is more than adequate to get the question to the jury. I think because it happens twice and she's told you need to come in tomorrow, we're getting close to contributory negligence as a matter of law.
Is it because you think those instructions would have fairly apprised her of a risk of death, or is it because you don't think that's a necessary requirement for a contributory negligence instruction?
It is not necessary that she be apprised of the risk of death. I think what is necessary, and these arguments come in the form of foreseeability. This is the nurse practitioner who's managing her pregnancy. This is a woman who has three children. So the idea that there's no way she would have known what an ectopic pregnancy was, or that pregnancies can have dangerous complications, or that you need to collaborate and work with your doctor and follow instructions. I think that's a jury question on its own.
Do you think there would need to be a reason to be aware of a risk of at least serious complications?
I think the crucial thing is she has to be aware of the risk of pregnancy complications.
One of my questions is about the magnitude. So here's a hypothetical. Imagine I go to the doctor and, I have a cut and I get like one stitch. And the doctor says to me, you should come back and have me take that out. If you don't, it'll diminish your otherwise wonderful appearance. And I think to myself, I'm not too worried about that. So I decide I'm not going to go back. So I now have been apprised of a risk and I've been given an instruction to return. And let's say I don't return. And in fact, there's a risk that if I don't go, if I do it myself and I don't go back to the doctor, that I could have, an infection that could cause death. And I get an infection and I die. Would you say contributory negligence should be submitted to the jury? Because although in the hypothetical, I'm trying to design it so you would think a reasonable person wouldn't really fear serious injury or death. I've been told why to come back. Seems relatively minor. But nonetheless, I failed in what you want to call a duty, though I'm a little unsure about the use of that term, and I don't come back. Would you say as long as there's a reasonable patient in my hypothetical position would have been on notice of a risk of some adverse consequence, then contributory negligence is submitted to the jury without regard to the magnitude? Or do you agree that in a hypothetical like that, if it's later than a wrongful death action, because I did pass away, would it be a good argument by my estate or survivors that maybe there was foreseeability and contributory negligence relating to something minor, but there's just no way on those circumstances that even a reasonable juror could find that the decedent was contributory negligent with respect to the risk of serious injury or death?
I think again, that the focus on the reasonable juror is what's crucial.
I know, but
think-
I'm just, the analytical piece I'm trying to sort out, and Judge Deal was, started this line of questioning is for contributory negligence to work, it seemed everybody realizes, I think everybody agrees that the allegedly negligent patient would have to acted unreasonably with respect to a risk. That's generic enough that I think everybody would agree with that formulation. I'm trying to make it so. And the question is it enough to get contributory negligence in front of the jury that there was an awareness of some risk, even if there was no reasonable awareness of grave risk or death, which is the cause of action that's at issue. So I'm trying to figure out what you think the requirements of contributory negligence are with respect to the claimants or decedents appreciation of the magnitude of the risk.
I think it's within the scope of the care. I think if it's a serious pregnancy complication, a failure to follow the repeated instructions of your pregnancy care provider.
Well,
But
the
how
reason I
does
find that
she-
ambiguous, the reason I find that ambiguous is because I can't tell whether you're saying there isn't a requirement. So how would you answer the hypothetical I gave? Let's take as a given that there is will be more abstract. You know, I go to a doctor tells me to do a thing. No reasonable, and it gives a reason. No reasonable person, every reasonable person would think I run a risk if I don't do that of having a minor consequence ensue. But let's assume that the facts are such that no reasonable juror could conclude that I would have appreciated any significant risk of serious injury or death. If those are the facts and the claim is wrongful death, does the contributory negligence issue get submitted to the jury or not? That's my question. In your view.
I'm sorry, I got a little lost in the length of it. So I'm not trying to be evasive. I think having a pregnancy is a serious medical condition. So there should be awareness.
And the gist of that argument
Yes.
is even if a requirement of serious injury or death being reasonably foreseeable by the patient exists, you think the record is met here. I get that. I'm just trying to figure out whether that is a requirement. And I just can't tell. In other words, if a patient sues a doctor or the decedents, the survivors of a patient sue a doctor and say, there was medical advice wasn't followed, but no reasonable person, if it's true that no reasonable person would have understood from the circumstances that there was a risk of death or serious bodily injury, does contributory negligence get instructed to the jury or not? That's what I'm trying to figure out your legal position about on that legal question, which has nothing to do with pregnancy or anything else. That's an abstract question about what's required in the law.
If it is in fact true that no reasonable person could have foreseen death, then it's never appropriate to instruct a jury on something that they could not reasonably agree with. I think the enormous middle ground of these contributory negligence cases are that it goes to the jury. And if the feeling of the bench is that, well, that's sort of silly, I'm not really buying that. Well, 12 jurors can say that. They can sit in a box and say, well, I don't think she was acting unreasonably. To pull that question away from the jury, to prevent the hospital from making that defense in a case where she twice fails to follow clear instructions.
So let me just jump in. So
Sure.
I think the answer to Judge McLeese's question is yes, there needs to be some evidence that there is a reasonable risk of death that the patient is aware of, right?
No, she needs to be aware that the question is, did she breach the duty to follow instructions and to cooperate in her
Right.
care?
And what I'm struggling against is this idea that a patient turns out to be female, turns out to be pregnant,
Mhm.
doesn't need to be given any information so that she can make an assessment of the risks. And that's what I hear you saying. So I thought you were answering Judge McLeese in a more reasonable manner to say, yes, the patient, in order to be found contributory negligent, or in order for this to go to a jury, you'd have to have some evidence to show that it was reasonable to anticipate risk of death. right?
I want to.
Now I hear you saying, no, that's not what I said.
I want to jump in on what I'm afraid is that could be a huge misconception. It is absolutely not the position that it's fine, the hospital doesn't have to give this advice. That's the negligence claim against Nurse Belknap. That's the claim, is that the hospital negligently failed to give this information. We understand that presents a case that's going to a jury. And that was allowed to go to the jury, and we did not oppose that going to a jury. The question here is there
Contributing
also an
some measure
instruction?
of fault to the
Yes,
patient.
that the
Right.
patient was contributory
Right, and when can we
contributorily
do that?
negligent.
And we're trying to figure out, does there
Yes.
have to be some appreciation of the risk by this adult person that there is a risk of death?
I think the law deems a failure to follow instructions or the, I think
Without
the,
more,
the law
is
deemed,
it because pregnancy is just inherently a life-threatening condition? Is it premised on that?
I think that's one part of it, but I think in terms of the duty to follow medical instructions, that duty is based on the idea that instructions you get from your healthcare providers are central. They don't throw out instructions left and right to do things for no reason. And they do,
No,
and
but
this is sort of,
sometimes they give instructions because they're convenient for them, right? Our office isn't open on Friday, so we want you to come in on Thursday, right? You have to come back within, this time frame because we don't have a spot for you at the time when you could come in, right?
if the patient agrees to do so and then fails to do so, I mean, that's what's so extraordinary about this case. You have a patient who's not only instructed to do something, doesn't do it. You have a patient who is twice instructed to do something and twice agrees
So
to do it.
she's asked to come in for a blood test,
Mhm.
right? With the blood test.
She's not asked, she's told she
She
needs
is-
to
she
do it.
is
And there is a difference. I'm
told-
not trying to be
She
difficult.
is told she needs to come
She
in
needs
for,
to do it.
she needs to come in for a blood test. Would the blood test have diagnosed an ectopic pregnancy?
The blood test would have, because, she also would
The
have been
blood
given the
test would have
ultrasound that
confirmed
day.
that she was pregnant.
She would have been confirmed.
My
correct.
understanding, according to the evidence, is that what she needed to diagnose the ectopic pregnancy was another sonogram.
Yes, and
Right,
the
of her
testimony is
fallopian
clear that would have
tubes.
happened had she returned on the 9th.
Was she told that she would get another sonogram and she needed to come in for another sonogram?
I don't know if the evidence is clear that she was told she would get another sonogram.
I thought there was no evidence that she was told that she was going to get another sonogram.
That may be correct. I can't recall.
What, and just to clarify,
I'm a sophisticated patient. I'm told I need to come in, I'm told I'm pregnant
Mhm.
and I'm told I need to come in for another blood test.
And you have an abnormal
I-
sonogram.
And I have an abnormal sonogram, but I'm told it could be for any number of reasons. And I go to WebMD and I say, what is a blood test going to tell me? It's going to confirm that I'm pregnant. I can wait. They want me to come in. I've got 3 kids. I've got other things going on. You go to the doctor a lot when you're pregnant.
Mhm.
I'll get back to them. They have not told me that I need to go back in for a sonogram because I have a life-threatening condition. Why am I contributorily negligent under these circumstances?
Because a patient.
Or why could a jury reasonably determine that I was? Seems
For 2 reasons.
unreasonable.
For 2 reasons. A patient has a duty to follow instructions. When you receive medical instructions, every person understands that there is risk involved in not following medical instructions. There's also a duty to cooperate in your medical treatment. What's again so extraordinary about this case is not that she says, well, I'm really busy, I've got kids, I don't know if I can make it, which would have prompted further conversation. Her response is, yes, I'll be there. That is the breach of a duty. We have 4 breaches. She says she
I will
breaches.
confess that, as I said at the beginning, and the case I was referring to is, I think, WAS, WAAS.
Lost for George
Yeah.
Washington, yes.
And every time you say that the patient had a duty, I have to say, I'm thinking, no, she didn't. So I just don't think there is a legal duty. I think that's a confusing, and I'm not faulting you because
Sure.
we've used the terminology. I'm just letting you know that every time, as you're predicating your arguments on that, my initial reaction is, well, that's not the right way of talking about it. There was no duty. There's a question of whether.
There's a duty to cooperate
I-
in WAS.
not a legal, not a duty in the way we thought it was better to talk about it in the footnote in WAS, which is like when there is a legal obligation that is enforceable by, lawsuit. I mean, my doctor can't sue me if I don't follow the instruction. I mean, maybe that you could, I imagine I could think of a hypothetical where maybe my doctor could sue me if I failed to follow an instruction in some way, the manner in which I failed it was independently tortious. But so I just don't, you run the risk as a patient if you don't follow instructions and something bad happens of not being able to recover in tort. I get that. That's certainly true. But wording it in terms of duties, to me, it just adds confusion rather than clarity. And to me, the issue in this case is not about that, other than, saying duty is not the right word again. I think the issue in this case more is, given the circumstances in this case, did the patient's reactions to the information provided amount to something that a reasonable juror could find was contributorily negligent in the relevant sense? And I think that's, yeah. So again, every time it's, she failed in she breached her duty 4 different ways. I get that doesn't resonate that well with me. So I'm just advising you. I just
All right,
and I keep wanting to say no, that she had no duty. So I'll say it once and then stop, or twice and then stop saying it. But
I'll share the genesis of that. Many jurisdictions and treatises recognize the duty to follow medical instructions. It is not deeply rooted in district case law. This court refers to a well-recognized duty to cooperate. So that does exist in the controlling precedents of this court. It is recognized a duty to cooperate. And I think that is a fair and reasonable expectation of a patient that they will cooperate. The assertion that Nurse Belna should have done a better job and should have given more warnings and been more forceful, that is the primary negligence claim, and that can be brought. The question here is there any question as to Ms. Dunbar's conduct and whether it was negligent?
It sounds like you're trying to divorce completely Nurse Belna's, the information that Nurse Belna provided and this so-called duty, right? Because in my view, those things would have a connection, right? If certain information were conveyed, then one might say somebody is contributorily negligent by disregarding the information. But we've been trying to figure out what information was conveyed, whether that information was such that it gave rise to a conscious, intelligent risk, a known risk of a life-threatening event. And I'm not hearing anything else other than, well, she just had the duty to do what she was told to do, and she wasn't entitled to any more information to escape a contributory negligence theory.
The argument is not she's not entitled to information. If the question is, failed to give us information
To escape a
that's the primary
contributory negligence theory, right? It's connected with the information, right? The negligent provision of information by Nurse Belna is connected to what Ms. Beatty did or didn't do.
Correct. The information that's given to her is the instruction you need to return. It's given on February 7th. Then when she doesn't return, she's called on the phone on February 13th. Nurse Belna tracks her down, says, you need to come in tomorrow. That's the information. Now, if the court's view is that as a matter of law, it is reasonable not to come in.
No, I want to pause there, because I think the question that we're focused on is not, is it reasonable? The question is, if it's unreasonable, does she need to be able to apprise the particular risk that she's in danger of? So it might be unreasonable to disregard your doctor's instructions. But if the instructions were let's just change the facts a little bit. And and on the first examination, it was, you need to come back in for blood work because otherwise you are at risk of miscarrying. There's no risk to you, Ms. Dunbar. But to make sure that baby is going to be healthy, we need you to come back within 48 hours. When she doesn't, they call back again and say, we really need you to come in. And then same fact, she dies. I think what's really, or at least holding me up, is that contributory negligence in a wrongful death suit. I would understand it as contributory negligence if she were suing the hospital for loss of her baby because they didn't take some preliminary steps. I don't understand because, some of these cases are cited in page 19, footnotes 15 and 16 of Appellee's brief. And that's Durfee, they cite in Sterling, and they've got Prosser section 65 and Feeney as well, where they say the injury which results needs to have been foreseeable to the reasonably prudent person. Sort of the proximate cause element of contributory negligence. And I've heard two answers from you, and I just want to kind of press on the second one. The first one is, well, she should have been able to appreciate that. She's pregnant. Everybody knows pregnancies are dangerous. Complications can extend to serious health consequences to the mother, including death. That's probably true, although I question whether or not it's true when you're talking about such a circumscribed period of time. It might not have been made obvious to her that, that was going to happen in 10 days, and that I think she died within 9 of the instruction. And the second aspect that I'm hearing from you is, well, she didn't need to apprise the particular risk because you have to follow instructions. And that's a surprising view to me. Because, doctors give you instructions all the time, come back to do blood work in 3 months. And it would seem if they didn't tell you it's because, you're on the verge of death and that blood work is going to save your life. My decision to wait a few more months would not be unreasonable. And nobody would find it unreasonable. So I just want to press on the second. But your position is, if it's an instruction given to you by a doctor, if you don't follow, that is contributorily negligent as to whatever consequence should come from it. Is that right?
It depends on the nature of the instruction, is one part. I think also it depends on the response. The patient does have an obligation.
So my doctor says, come back in 3 months for blood work. And I say, okay,
if you say,
I'll be there in 3 months. Then 3 months comes around and I have a work trip that comes up. And I say, I'll do it 2 weeks later. And it turns out that my doctor, unbeknownst to me, was really looking for a particular type of, thing that could be cured in 3 months, but was likely to lead to death in 3 months and 2 weeks.
If he calls you and says, come in tomorrow, you have to come in tomorrow. Then it creates a question that a jury can fairly consider as to whether you were contributory negligent.
And is that because somebody would understand that to mean that they are at risk of serious injury or death with such an urgent instruction, or because, following instructions is good?
It depends on the nature of the treatment. I mean, who's your care provider? What is it about? I think for pregnancy care, the risk of a pregnancy complication is within that foreseeable scope. I think if, to take, a different example, if I'm told to go to my dentist for a cleaning and I sue a physician for, not detecting melanoma, and he said on my forehead, and he says, well, if you had only gone to your dentist would have picked it up. So you've breached the duty to follow instructions, which we know Judge McLeese hates, and therefore you're out. Well, that is disconnected. That's not within the realm of consequences I can reasonably foresee for not going to a dental cleaning. But any pregnancy complication is within the realm of the risks you run when you are twice instructed by your pregnancy manager to return promptly for blood testing. The first you're told come in 2 days, you're then reach by the phone and say, come in tomorrow. I mean, that's an unusual circumstance. I don't have my doctor calling me.
I may have missed it, but I'm not sure I heard an answer to the exact hypothetical Judge Steele posed about rather than an instruction without an explanation, which is arguably what our case is more like. And instead, there's an instruction in the hypothetical about miscarriage that is where one reason is specified. Come back and do X in a particular period of time to prevent a particular risk. And it's not that problem that arises. Instead, a different problem arises. It would have been presented if the patient had obeyed the instruction with respect to miscarriage. Is it your view that that's a contributory negligence case that goes to the jury or not? I'm not sure. I may have missed it, but I wasn't sure what your answer to the question was. In a hypothetical.
I think my answer was it depends, and I would want to flesh out the facts more in terms of what's the nature of the care that's being provided. It is a fact dependent.
I'm saying let's say we're on summary judgment. Those are the facts that have been presented to the judge who has to rule on the summary judgment motion. Submit that to the jury or not. As a litigant, I'm sure you would generate more. And as a
it would go to what is the care that's being provided.
I'm just asking, assume that it's not well litigated and those are the facts that are submitted.
I think there's a presumption that a failure to follow medical instructions creates a jury question on contributory negligence.
That implies an answer, but just to be clear, you're saying you think that would go to the jury.
Yes.
On the theory that
Ordinarily,
on the theory that the jury, that a jury, again, this is, I'm a little unsure whether on the theory that a jury could reasonably find if they're warning such a patient about miscarriage, the patient reasonably should fear other consequences like death. That's one line of thinking. The other line of thinking is doesn't matter. There's just sort of a without regard to the risk that the patient would reasonably appreciate. If some risk that would have been prevented by following the instruction arises, you're foreclosed. Do you sign on to both those reasons for submitting to the jury, or only one of them?
I share your refrain of reasonableness. I think that's the question. And that goes to sort of foreseeable. Foreseeability is actually framed as reasonably foreseeable. Is it reasonably foreseeable that something could happen? And I think the critical inquiry is who decides these questions of reasonableness and foreseeability. In the vast majority of cases, it is the jury that has that role. So we need to decide, is this that extraordinary case that's in that stripe where her behavior is negligent as a matter of law, which I think we are close to? Or are we in that narrow stripe on the other side where her behavior is reasonable as a matter of law? No reasonable juror could possibly find that she should have gone to those appointments and that she risked pregnancy complications and possibly severe pregnancy complications. I agree that if the injury is not just, I didn't anticipate a severe injury, but it's not a pregnancy complication. I didn't go to the dentist and missed getting my melanoma. That's not a foreseeable injury. So there are other ways into this analysis that keep it from running infinitely wild. There is foreseeability. And we argue that it certainly presents a jury question that not following the instructions of your pregnancy provider twice in 1 week creates a risk of a serious pregnancy complication. And it does not require the specificity that, well, did she have to know it was ectopic pregnancy? Did she have to know it was death? What's crucial also here is this is a woman who had 3 children, had been pregnant several times, and was had a 15-minute conversation with her doctor, which included a differential diagnosis that included ectopic pregnancy. So to say that no reasonable juror could find that she was advised that there could be an ectopic pregnancy as one of the issues, I think that's also, there's enough there to create the question for the jury. But the most important part is what this court recognizes as the duty to cooperate. She's twice instructed to do something and she twice agrees. That's what's so exceptional about this case. She doesn't say, I'm a mom of 3 kids,
Counsel,
I'm really busy.
I think we have your argument at this point.
Sure.
So we'll let you sit down. We'll hear from
Thank
you again on rebuttals.
Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors, or is it evening? May it please the court. My name is Mark Fiedler. I represent the appellees in this matter. I'd like to jump in on a comment or question that Judge McLeese made that, at least as I scribbled it and understood it, that went to the question of how much does the plaintiff need to know in order to trigger that obligation to exercise reasonable care under the circumstances. And to swing back to something that Judge Easterly touched on, the answer is provided by the informed consent cases, particularly Crane and its progeny, which expressly say that at a minimum, a healthcare provider must divulge, among other things, the nature and degree of the risk of abstaining from the proposed treatment.
So
So,
are you trying to defend this as an informed consent case or
well, it certainly is that, but
what?
but
I'm going to take you back to what appellant's counsel just said moments earlier, which is, look, there's no question that there's a negligence claim here. The question is whether or not there's a contributory negligence defense. So
Then let me elaborate a little bit. It's that the two most salient legal principles that govern the contributory negligence issue, in my view, is number one, to maintain a contributory negligence claim in a medical malpractice context, the defendant must show that the plaintiff knew or should have known of the risks and dangers associated with the medical treatment. And we could get back to that. It may not even be that harsh. It may be know or appreciate. Well, let's assume it's know or have reason to know. The second principle is that to enable a patient to make an informed and intelligent decision about undergoing or foregoing medical treatment, the healthcare provider must disclose, among other things, the nature and degree of the risks of abstaining from the treatment. And this is a case of, foregoing or abstaining from the treatment. So the two.
Make sure I understand. Are you saying that second requirement, you understand that to be a component of a contributory negligence defense? You have to both establish that a reasonable, if you're talking about whether to get to a jury or not, you have to establish that a reasonable juror could find that the plaintiff or decedent knew or should have known of a risk and failed to take steps to prevent it. That's step one. But step two is a separate requirement of contributory negligence. Are you saying that the medical professionals whose conduct is at issue need to have provided adequate information to the decedent / plaintiff with respect to those topics? That's a distinct requirement. That's a distinct requirement that has to come from the medical professionals.
Right, because, and I'm not trying to make any grand pronouncement about all cases, but in a case like this, where the only evidence of record about what Tiffany Dunbar knew or should have known about the risk of abstaining from the medical treatment came exclusively from Nurse Belknap. And so there's some speculation. Well, she had been pregnant before, so therefore she should have known. There's no evidentiary basis for what she knew.
What's strange about talking about this case as an informed consent case is, what do you even mean by abstain from medical treatment? Was there evidence that she wasn't going to eventually go back for a blood test, eventually go back and seek treatment and medical care for her ongoing pregnancy had she not died? I mean, it strikes me that she never made a decision to abstain from treatment. She delayed it. I mean, that's what informed consent cases are. This feels like a more classic contributory negligence case, that if you try to weave informed consent into it, you can kind of weave it into every contributory negligence case.
Well, in a medical malpractice context, where again, the patient's knowledge of the risk is dependent on the disclosure from the healthcare provider. Yeah, I think the two are going to be intertwined.
What's your best case for that proposition? I mean, we don't see, we have a whole lot of contributory negligence cases. Never do they quite dovetail with an informed consent theory the way that you're advocating for today. But I mean, tell me what you think supports that view of contributory negligence.
A logical extension of what Crane had to say, dovetailing into what was said in Durfee, Rotan, and the earlier cases about knew or should have known. The plaintiff needs to know or should have known of the risk in order for a contributory negligence defense to be maintained.
I'm not quite sure I'm following what informed consent adds to the analysis as a distinct matter. I get your point that in a case assuming this were one, where all of the evidence comes from the medical provider about what the patient might have known about the consequences of delaying recommended treatment or diagnostic techniques. There's going to need to be a focus on what was said there, but you seem to acknowledge that in other cases that might not be required. So again, in a case, let's say there was evidence here that, after these recommendations from or directions from the doctors about or nurse practitioner about what to do, Ms. Dunbar had gone back and had, gone on the internet and looked up ectopic pregnancy, and you had search history that showed it said risk of death. And, and let's say that she had spoken to somebody about it. So we knew that although no one had explained it to her, she knew. You would agree that contributory negligence would be instructed to a jury, even though in your view, the medical professionals would have done a standard job of communicating risks.
That's right. I'm leaving open the possibility for other cases where.
So why do we have why get into informed consent as a distinct topic at all? Instead, the issue is a single issue, the contributory negligence issue. It's got some nuances for sure, but roughly speaking, it is given what the patient was told, knew from other sources, what people, and given what reasonable jurors could infer about those two things, the issue is whether in a case like this, the patient's failure to or decision to delay, apparent decision to delay diagnostic, recommended diagnostic techniques reflected negligent disregard of the appropriate type of risk. Why do we need to get into informed consent at all? It's just as a separate doctrine. It's just part of part of the material that you would look for in a case like this is what did the medical professionals tell the patient? What did the patient know otherwise? And you'd throw that all in a hopper and you'd figure out whether there was enough there to get contributory negligence to a jury. I'm just not quite sure what informed consent adds as a distinct concept.
Because the defense of contributory negligence includes as an element that the plaintiff has to know or have reason to know of the risk. And in a case like this, where the only source of the knowledge of the risk is coming from the healthcare provider, well, then the question arises, and it was presented squarely to the jury. Did Nurse Belna disclose to Tiffany Dunbar the risk, and I'm quoting what the jury instruction was, the likelihood and degree of risks of not getting treatment? The jury was instructed on that, and they effectively answered that question no, when they found that the hospital, through Nurse Belna, failed to obtain informed consent. And by the way, because of that finding, which negates the knowledge, the critical element of knowledge of a contributory negligence defense, because of that, the court doesn't even need to reach the question of was there sufficient evidence to go to the jury on this instruction, because it would be harmless error. The jury already decided that she didn't get the information that she needed about the risks. And
the premise of that line of argument is that a reasonable juror couldn't have accepted some of the points your opponent's making, which is that applying common sense, a juror could think, look, if a juror might think, I know, and reasonable people are going to know that pregnancy is a dangerous condition. It leads to serious consequences. And if someone says you may be pregnant, I see abnormal things on a medical test, you need to come back, and then reiterates that a reasonable fact finder applying common sense could think that, as the fact finder might think, Ms. Dunbar, if she were acting reasonably, would have understood that there was a risk of medical consequence if she delayed and failed to follow those instructions. And if this is required, which is, I guess, something that is still to me a little bit murky about what the parties' positions are, maybe that there's a risk of serious complications, including up to and including death.
Yeah.
Why you think that no reasonable fact finder could be drawing any inferences along those lines, and everything had to be on exactly what was said from the medical professionals?
In this case, yes. And again, and at the risk of beating the dead horse of Crane versus Allison, what Crane said is that a decision on medical treatment that is not properly informed is ineffective. Okay, and the court also said at a minimum, this is what the patient needs to be informed about. And so in my view,
You're
it
not,
makes
again,
the
you're
court-
not going so far as to rely on that for the idea that even if you're, even if the decedent here should have known or actually did know that there were risks, that a contributory negligence claim should be barred because there's a requirement that the medical professionals provide that information and that wasn't done. So whatever she knew or should have known, if she wasn't told, contributory negligence is barred. I thought you were saying you aren't making that argument. You're not treating that as like a separate prerequisite that it has to come from the medical professionals by way of adequate advice.
Well, I'm not saying it has to come from the healthcare provider in every case, if there is evidence of the record that the plaintiff otherwise knew or should have known of the risk.
So, but
here it's
then if you're relying on
entirely
Crane, if
speculative.
you're relying on Crane for the idea that her decision was ineffective because it's only effective if the medical professionals tell her what she needs to know, that seems broader than what you're acknowledging, which is the real issue here is not only what the medical professionals told her. That's not fatal if what was told here was inadequate under an informed consent theory or a variant of informed consent. It also, there's also an inquiry into whether, given what she was told and given what a reasonable fact finder might infer, people would reasonably understand, she should have known. That's still an open question, even if there was a failure to give the kind of advice that the informed consent instructions here would require the medical professionals to perform.
But there's no evidence of record that she knew or had reason to know of the nature and degree of the risk.
I mean, that's kind of the dispute between the parties here. So their response is, look, you've been told you're pregnant. There's evidence that she's told she's pregnant, that she's told there's an abnormal ultrasound, that she's told she needs to come back in 48 hours. And when she doesn't come back within 48 hours, she gets a call that same day directing her to come back the next day. And they say, well, you take all that together and a jury could find, we might not agree, but a jury could find that a reasonable person would understand there's a serious risk to Miss Dunbar, that given the urgency with which they're saying, come back, the abnormal ultrasound, sort of the inherent difficulties of pregnancy where it can be, life-threatening condition, she should have known. And a jury should have been able to assess whether or not she should have known that was a risk of ignoring the doctor's advice. So, I mean, that's their pitch. And what's your reaction to that?
First, there has to be evidence rather than speculation.
I don't think anything I just said was speculation. I mean, we're talking.
But think about, you're saying you're pregnant. And as I understood what you said and what was said before, pregnancy could be dangerous. If that's the case, anytime a pregnant woman goes in for care and is told you're pregnant, they now are contributory negligent as to the whole panoply of risks that could be associated with pregnancy, no matter how well educated the plaintiff is. That doesn't seem right to me. I don't think that's consistent with the law. And it's certainly not consistent with what Morrison, Durfee and Rotan say about the disparity in knowledge and experience.
But Judge Steele said it's not just that she's told that she's pregnant. She's told you're pregnant. There's an abnormal sonogram. You need to come back.
And why that's insufficient is it doesn't convey to Tiffany Dunbar how serious her condition might be, the urgency of having to come back, what could, and what are the consequences if you don't? And that's how I understand what Crane means by the nature and degree of the risk. Remember here, the risk, the one that the most serious risk and the one that materialized was death. And Nurse Belknap expressly and repeatedly testified, I would not have told her that she could die. That was the risk. That was the risk in this case. So her testimony effectively negates the element of, the critical element is what this court has called it, of knowledge of the risk. So
To be clear, it's not knowledge, it's knowledge or know or should have known. So it's not absolute knowledge.
well,
right?
this is interesting, and sorry, I'm going to go off on a slight tangent. If you look at the older cases that don't involve medical malpractice, I cited a 1960 case called Feeney. I decided a case, I think from the 80s called Sinai, and they talk about knew or should have known of the risk in a contributory negligence context. But then you take a look at Rotan and Durfee, which is now in the medical malpractice context, and they take out the should have known. It's knowledge and appreciation. And that it's an interesting question that's not yet been explored by the court. Is that component, that element of a contributive defense somewhat diluted in the medical malpractice context for the reasons stated in Morrison and Durfee and Rotan, namely disparity in knowledge? Plaintiff is entitled to rely on the expertise of the healthcare provider and so forth. It's an interesting question. I don't think the court needs to decide it. We argued it in our brief, and I'm arguing today a knew or should have known. But I think a plausible argument could be made that it's more than that. And by the way, if you notice in our 28K letter, we cited the ethical rules which nurses are required by DC law to follow. It talks about the healthcare provider, the nurse, making sure that the plaintiff understood. It's not just, needed to come back abnormal. It's, do you understand, and do you understand why? So it contemplates that shared decision making. It talks about it, in fact, joint or shared decision making expressly. But there's got to be that give and take so that the plaintiff does understand, or in the words of Durfee and Rotan and Morrison, appreciate.
Can I just ask a quick,
happy to answer more
a
questions.
quick factual question? So she's told to come back. She's told you need to come back in 48 hours on the 7th. And she does not return on the 9th. Is she called on the 9th?
No, and she wasn't called on the 9th. And Nurse Belna wasn't even there on the 9th.
And when is she called again? Or what-
13th.
On the 13th. And she is told on the 13th, you need to come back tomorrow?
For a blood test, yeah.
Okay. Sorry.
I was just gonna, not to cut anybody off, but I wanted to talk about damages for a little bit. Could you, I guess the first question is, do you agree with the hospital's position that under the Wrongful Death Act, only pecuniary losses are compensable?
Your Honor, at the risk of sounding anti-semantic, pecuniary, it, as Brian Garner points out in Black's Law Dictionary, is redundant. All damages are pecuniary.
Okay, well, let me move then. Why don't we talk about financial? Because the jury was instructed that when compensating under the Wrongful Death Act, let me just pull up the site. I think it's at appendix page 766. The amount to be awarded under the Wrongful Death Act is the financial loss suffered by the next of kin of Tiffany Dunbar, who are the beneficiaries under this act. Now it then goes on to talk about things that sound distinctly non-financial to me, parental guidance, advice. And we have said, I think it was in Hawkins, if I'm getting the case name right, that's different from loss of consortium, but very, very tough to figure out how one would quantify. So I don't know what it means. I mean, I guess, tell me your understanding of what our case law is. So this, and do it through the lens of the instruction that the jury is given. The jury is told, you get to award financial damages underneath the Wrongful Death Act. And that includes sort of standard, we'll call them standard loss of services, things that can be replaced through monetary, you can hire people to do house cleaning work, you can hire people to cook and to take you to school, stuff like that. And then this sort of other bucket of, and then there's like the things that parents do for their kids that, the nanny's not going to do. They, they talk to them when they're crying at night. They deal with their, unless you have like an on-call therapist, you don't really replace a parent by hiring somebody. So what's your understanding of the state of our law and sort of what you think the jury, is it right that they can only award financial damages? And if not, maybe you've waived an objection to that because that was the instruction. And then what does it mean to talk about parental guidance and advice as a financial damage? I know that's a lot. I mean, do your best. I find the case law quite confusing. If you do your best to disentangle that in 30 seconds.
So, the DC Circuit was encountered that issue in Elliott versus Michael James. And they sort of disavowed that pecuniary means narrow, mathematically precise damages. They cite Judge Holtzoff in the Horde case. For propositions that, where the plaintiff prevails in a death case, substantial damages should be awarded. They also say, and this was carried over into Binker, Doe versus Binker, that the award of damages cannot be mathematically calculated with mathematical precision, that expert economic advice or testimony is only a guideline, and that it's left to the good sense and sound judgment of the jury. And I would add, and that sounds like just throwing it to the jury, but I think it would be fair to say good sense and sound judgment of the jury. And by the way, I left out on all the facts and circumstances of the case, but under appropriate instructions from the court. And here the court gave appropriate instructions about don't award for grief, don't award, for loss of love. And counsel even argued that point in closing. That's what we're here for.
Can I ask you about another aspect of the instructions? Because on the next page, 767, the instruction goes on and says to the jury, you should set a dollar amount on the reasonable value of any service that the deceased would have provided to each beneficiary over their joint life expectancy. Then it's supposed to be discounted to present cash value. So I gather you're endorsing these instructions and you haven't objected to them in this court. So you think that's with respect to parental, and this was immediately following the discussion about loss of care, education, training, guidance, and parental advice. So do you think that what the jury was told under the instructions to do was to take each of those as a service that the parent would have provided during the joint life expectancy of the parent and the child? And the jury was supposed to set a dollar amount on the reasonable value of those services and to be, as you pointed out, to exclude any amount for sorrow, mental distress, grief, loss of love, loss of affection. Do you agree that that's a correct description of what the jury's task was under the Wrongful Death Act in setting the damages amount with respect to that category?
Excuse me one moment, Your Honor, with the court's indulgence. I got it.
I'm on appendix 767. It was the language I was focused on that's new from what we've been discussing thus far is on line 6, line 6 to 10.
On page 6. So, as court knows, jury instructions must be viewed as a whole. So on page 766 of the appendix, I believe the court said, if my notes are correct, in deciding upon any damages which will reasonably and adequately compensate the beneficiaries for the death of Ms. Dunbar, you must consider the loss of care, education, training, guidance, and parental advice.
Right.
So
and then my point was for sure that's there. And I mean, there are 4 propositions that are all lined up here in these paragraphs. One is financial loss, whatever that might mean. Another is exclude a bunch of things that you think of in more capacious forms of damages like suffering and grief and all that. That's number two. Number three is there are these categories, that you need to consider, which are, loss of care, education, training, guidance, and parental advice. Then fourth, it says, with a couple sentences in between, set a dollar amount on the reasonable value of any service that the disease would have provided. I was interpreting that to be a reference to those categories of things, of services parents would provide. They'll give you advice. They will give you support. They'll give you education. They'll give you training. And the jury seems to have been told to set a dollar amount on the reasonable value of those services over the joint life expectancy of the child and parent, and then to discount that to present cash value. Now, obviously, they can't. It's for sure correct that nobody's going to be able to do math very well on that, although you could try. I mean, you could talk about life coaches and tutors and try to, get economical in very specific terms about all of that. But I just wanted to make sure that we take into account that language too, which does seem to focus on an admittedly vague concept of pecuniary or financial, seems to focus more on the financial value of those services and less about the loss that a child, of course, would feel by not getting, that from a parent and the grief and sorrow that you would miss by not getting that. Do you think that's a fair understanding of what the jury was told there, or you don't agree with that?
Well, I could tell you what my understanding is, and I hope I'm not wrong about this. This wasn't the standard jury instruction on wrongful death damages. Plaintiff proposed a special instruction. And I hope I'm not misstating the record that the defendant acceded to this request. And
Yeah, I believe it's at 7 of 7.
What was different about this instruction is it broke down the loss of household services into two components. The one being the ones that could be obtained in the marketplace, which is what Dr. Lindsley testified to, like, a housekeeper, laundry service, things like that. But the other component, at least this was the intent behind it, the other component isn't so, limited to estimates by an expert: care, guidance, training, education, advice. So yeah, the word financial is in there, but the intent was to sort of subdivide that component of damages.
Yeah, I think you expressly referred to that bucket as non-economic damages at page 707 and 708 of the appendix. And then I think you're right that the hospital says that's fine in terms of the instruction.
I'll be happy to answer any other questions. If not, I'll conclude simply by saying the trial court managed this trial conscientiously and fairly, there being no reversible error. This court should affirm the judgment in all respects. Thank you.
Thank you, counsel.
Yeah, 5 minutes of rebuttal.
Go ahead, Mr. Cycleather. You've not had an opportunity to speak to the damages issue, so I'm sure we'd like to hear from you on that. And if you have, I don't know if you want to quickly address anything in rebuttal on contributory negligence, but then you can move on to damages.
Yeah, I've got.
Or you can take it in reverse. I'll let you.
I think I've got a logical path that's an efficient use of everyone's time. I just want to make one last point on contributory negligence. And what I'm anxious about is I don't want this court to create a rule that medical instructions without warnings just aren't instructions. But to illustrate, I had knee surgery and I was instructed, don't eat after midnight. They didn't tell me why. They said, just don't eat. I showed up at 6 a.m. They said, did you eat after midnight? I said, nope. Then they went away for an hour or so. Then I had my surgery. If I had eaten and just said no, that would have violated, I think, my duty to cooperate in my treatment. If in the hour after the nurse left, I got bored and ate a few granola bars because they were taking longer than I thought, and then had some horrible surgical complication. To this day, I don't know why they tell me not to eat before surgery. Is it glucose? They don't want me to have bowel functions on the table while I'm out. I don't know why, but I follow the instructions. And if I had some horrible surgical complication after eating granola bars, after being instructed, and I said, this doesn't even present a jury question because they didn't tell me why. They just said, don't eat. And I thought they were just saying because it's convenient and it's Tuesday and we don't want to do this. Instructions without warnings still mean something. And the line, what Durfee stands for, is these are jury questions. Durfee was a case, as you recall, that was decided as a matter of law in favor of the defendant. And because there wasn't even causation proof that was clear, they said, we didn't even know if not following instructions even caused this injury. But they said, more to the point, these are jury questions.
I mean, it strikes me that your hypothetical is unhelpful. I mean, I take your point that you don't want a rule that is not, that is overbroad. But as far as, hypothetical where a patient actually affirmatively provides incorrect information to the doctor, did you eat? No, that's untrue. That would seem to be a different distinguishable scenario, right? Did you eat? No, that's true. And then while you're pre-op, you do eat. I mean, I would think that the scenario itself of being pre-op and in a gown and would communicate some information to you that is not akin to information that would communicate more information to you as a patient than was communicated to Ms. Dunbar in this case.
And I think the law.
So I think that there are factual distinctions that can be drawn that can address your issue. I'm just wondering if you have anything more on the law about how we should think about appreciation of risk.
I think the duty to cooperate creates a question.
Okay, I think we've heard you on the duty to cooperate. So we understand that argument.
Yeah.
Do you want to move on to damages?
I will, yes,
Okay.
and thank you for that. I think the damages point is crucial because here the plaintiff's expert economist gave what is often a plaintiff-friendly view of lost services and valued them at close to $690,000 for what was over 10 hours a day, 7 days a week of Ms. Dunbar's services she's providing to her 3 children. Crucially, it included helping with homework, things that would come under education. It included, time spent with the children. Presumably includes, singing lullabies, special songs that moms like. This was a global, comprehensive assessment of all of the value reduced to present value. And it was reduced to, I believe, $689,000. And the jury awarded over 100%. They gave $692,000. I don't know how they got that 1% delta, but they did. And we have not appealed that. The question then, because non-pecuniary losses, sentimental loss is not recoverable under the clear terms of the Act, because the Act gives explicitly the appellate court the power to order remittiture on appeal.
Okay, can I just pause you there? What plain terms of the Act? I went searching through the case law and you were mostly citing, I think, to Elliott and Himes as your best cases, saying there's no non-pecuniary compensation under the Wrongful Death Act. And I went back and looked at our cases. They strike me as less clear. And then I went back and looked at the statute. I don't find it clear at all. So what are the plain terms of the Act that you say?
I believe there's a citation to the statute on page 40 or 41 of our opening brief.
I mean, I've read the statute. I'm just curious what terms you think say.
It has a citation, which I believe is correct to the statute, and not just the case law.
No, I mean, I have the statute. I just want to know what language in the statute you find clear that you're limited to financial. That our case law definitely says you don't get grief or suffering or loss of consortium. The Wrongful Death Act itself is not very clear on that. I think our cases have just said, because this is in derogation of the common law, we're going to read the damages that are available under it pretty strictly. So we're not going to allow you to get this stuff, which was never available at common law, and they didn't clearly mean to revive it. I don't see anything, but I'm just reacting to your statement that under the plain terms of the Wrongful Death Act, you need to sort of have a quantifiable financial loss. And I don't see anything in the Act that says that. And if you have it, I'd love to hear it.
I misunderstood. I was speaking to the idea of appellate remediator.
Okay.
Which is explicit.
Yes,
in the
correct.
act.
That
And I
is
share
correct.
your sense of,
Understood.
it'd be nice, all these cases have these, clear black letter law. It'd be nice if that one sentence appeared in the statute. And it is, more difficult to pull that out. So I think we're all in agreement that the statute expressly provides for appellate remediator under the Wrongful Death Act.
Right.
And that it's less crisp than the controlling precedents, which say you cannot, it's limited to pecuniary loss. You cannot recover for grief and sentimental loss. What we have here is on this unusual verdict form, which was agreed to by the parties, but this unusual verdict form, which breaks what normally appears as one line into two lines: loss of household services, and then what's often elements of loss of household services presented as a separate line.
So if you agreed to it, why do you get to argue about it now?
We're arguing excessiveness. We're not arguing that the jury verdict form was improper. That's the argument that's waived. We're arguing that the amount awarded was not supported by the evidence.
But isn't your excessiveness argument sort of premised on this improper bifurcation? Am I missing something?
I think the bifurcation is redundant. I don't
Right,
understand.
and so
Correct.
that, it seems like you should have then objected to the form at that point and said, this is redundant. It's only going to lead to an excessive award, because you're essentially asking the jury to make a duplicative award. You're telling them to, award for these services here, and then, you're telling them to award for the same services over here.
Correct. The
So
award.
why isn't this waived?
What is waived is the objection to the structure of the verdict form. What is not waived is the requirement that the ultimate award not be excessive. What's not waived is the argument that the award be supported, have an evidentiary basis. And that's what's missing, because the evidence here was so clear that the plaintiff's own economist, taking their most favorable view of the case, valued the totality of the loss of household services at $689,000. And the award was
That gets me a little confused, because that's a separate item line from.
correct.
And so their expert wasn't purporting to address, I gather from what you're saying, that in your view, partially duplicative, but in any event, certainly at least to a degree, potentially distinct category of damages.
The problem is that the expert he talked about help with homework.
I understand that, but just in terms of the way the expert couched, did the expert use the phrase household services in describing what the expert was testifying to?
Yes.
And your point is that although the expert in terms was addressing one category, your point is that substantively, the topic that the expert was addressing to a degree overlapped with what was presented to the jury as a distinct category. I get that particular point also seems a tough one to raise. And if there were if your only issue was, well, there was double counting, then if this number had, if the number on parental advice, et cetera, had been, 132,000, and your point was, well, there might have been overcounting there, they're duplicative and the testimony was confusing, you'd have a hard time making those points, having not.
Correct.
But
Yeah.
I just was trying to make sure I understood the expert testimony that you're pointing out had a relatively small compared to the award in the category of parental advice, et cetera, had a small number. I was trying to understand, and I gather from what your answers are that the answer is the expert couched the testimony as focused on household services, not as focused on this category, which again, could potentially be viewed as overlapping.
I don't think he drew the clear distinction that shows up on the verdict form. He explicitly said this includes help with homework, which I can't construe as any other than parental education, and sort of the guidance there. So the question then is, if that component, and what's crucial here is he fixed the time to it. This is a woman who had a part-time job, and he said over 10 hours a day are going into this 692,000. And the jury is not, obviously, he said 689. So the jury has the discretion to go to 692, and they have some flexibility. What happened here is the jury awarded 15 million on top of that. And the question is, what on earth is that compensating? And
I have some reactions. Here's one. Household service, I'd have to go back and look at the expert testimony. But household services for the 10-year-old, how many years was that covering? I assume something like 8, presumptively, how long he's going to live at home. And one argument that they made is parental guidance and advice doesn't stop when your kids leave the home. That's going to be a 50-year job. And the type of who are you going to call when your marriage is falling apart? Usually mom or dad might be a decent option, and that's gone. And I mean, one reason why the number might be a lot higher is because you're not limited to sort of like the 8 years that they have remaining living at home, but sort of a long time confidant and you know, really therapists for some people. I don't know.
Well, the 10-year-old already lived with her father. She had 2 children at home, and the 10-year-old was living with her father. So it was not mom with 3 kids at home. It was mom with 3 children, 2 of them at home, 1 lives with her dad. And the issue is, you know, is there some room there? I understand the arguments that they're in that space between the unrecoverable sentimental loss and the what is a very large $692,000 for household services at 10 hours a day. There can be some shadow of an area. I think it might be completely redundant or would be very small, but I can understand arguments and say, well, no, I could see how it could be a sizable number. It cannot be 22 times the 10-hour-a-day work that mom is putting in. It's just a number that's so insanely high that
You say it can't.
Yes.
Do you have a case that says it just can't? These sort of, could we possibly even call them sort of priceless lifetime services of having a parent in your life, guiding you in life decisions about whether or not to get married, whether or not to get divorced, whether or not to buy a house, whether to move, whether to get a dog, whether to have children, how many children you have, all of those things, right? That a parent might be in your life for as part of your family, right? Do you have a case that says that can't be 22 times the household services that are the more mundane tasks of doing the laundry and washing the dishes and, you know?
Not one that says it in the terms of 22 times a ratio like there would be with the punitive damages award, but we know, you know, punitive damages can't exceed 4-to-1 ratio or 10-to-1. I forget what the law is on that, but there's a rule of reason that plays into even, you know, punishing abominable conduct. To award 22 times what is sort of the full-time work of a mother.
I guess part of the premise of my question was it wasn't quite clear to me what the relationship is between the day-to-day household activity of cleaning house and these other services that Judge Deal was alluding to, and then I discussed. Why is there any sort of, you know, why does it have to be a factor of that?
I would go back to, this is over 10 hours a day. It's not just the cleaning the house and the stuff or having someone mow the lawn instead of having mom do it. This is helping with the homework, reading the bedtime stories, fixing the costumes. This is the global package of everything that the mother is providing for her children. So I think to break the instruction created a redundancy, which, you know, we're stuck with on the jury form, but there still has to be evidence of something outside of that that's worth 22 times. And what is worth 22 times the cooking and cleaning is a mother's love, is having a parent. And they were told in oral argument, think about replacing mother, not having a mother at holidays, first dates, driving a car. These were rank, sentimental, heart-pulling Hallmark commercial appeals.
And unobjected to?
They were not objected to, and they worked. And the question is, if you're going to win a moderate and reasonable award, and you slip in an impermissible argument without objection, and you get a large permissible award, well, then you've gotten away with it. But sometimes trial tactics are too successful. And these sentimental appeals, this improper Colston argument, anchoring out these numbers, this million, you know, whatever you want. These improper arguments caused a nuclear verdict, a runaway verdict. And the question comes back to, what's the evidentiary basis? And it's clear in reading this, what prompted this massive reaction. This is for the love of a mother. This is sadness for children who don't have their mother. And the case law says, as commendable as that is, as understandable as that is strictly forbidden under this act. And that is part of the reason this act explicitly writes in the capacity for appellate remediator. I've done a lot of appellate law. It's so rare to see that in a statute providing for appellate remediator when the normal context is defer to the jury, sanction the jury, loath to second guess. This says appellate remediator is appropriate. And I think
and just so I understand our standard of review, as I understand it, it would be the question for the trial court was whether or not any reasonable jury could have come to these numbers. And we would have to say on appellate review, the trial court abused its discretion in concluding that a reasonable jury could have reached those figures. Do I have that sort of dual layer of deference accurate?
Yes,
Okay.
yes, that is correct. And it's also in the context of a statute that is specifically written into an appellate remediator. So which sort of cuts against the traditional approach. So the court would, blend all of those together and looking at how is this act applied. But I think because of the starkness of the arguments that were made in closing, it's clear this was an award for sentimental loss. And in particular, again, this case has so many exceptional facts because they carved out the 10 hours of household services and all that mother does at $682,000 on top of what totaled more than $2 million in an award. They then gratuitously added a $15 million award that is clearly driven by sentiment and sympathy and loss, which, as understandable and commendable as it is completely impermissible under the statute. Thank you so much for your generosity with your time. I really appreciate it.
Appreciate your argument, Mr. Stikelether. Appreciate your argument, Mr. Fiedler. The case will be submitted and this court stands adjourned.
All right.